Lordship, may I permit to seek leave?
Madam,
Lordship,
Thursday.
I am to seek leave. I am seeking leave to file an appeal without certified copy. Order dated 29 August 2025. And another is of order dated 4th September. I have applied for the certified copy.
So wait, madam, what is the urgency?
Lordship, one matter is regarding upper primary selection process.
Upper primary selection process?
Lordship,
Which one? The examination which is going on?
Lordship,
Do you know that?
Lordship. One matter is
Madam,
regarding.
please, when you mention, please ask your senior. The court will be asking these points. Now, if you show us the order. কাজ করছে ওটা যদি রিকমেন্ডেশন এক্সপায়ার করে গেছে এখন বলছে সিমিটা দিয়ে দাও ইয়েস কল দি লিস্ট
Grateful.
Well, excuse me, my lord. I have already made so many minutes calls upon my client for contact with me, but he did not my lord, return this. And ultimately, my lord, the entire brief has been taken away. Now I have already taken my learned friends of this brief, my lord. I have to ready by tomorrow or day after tomorrow if your lordship, my lord, kindly enough to.
No, place it today. Repeatedly you are taking.
Well,
place the matter.
Well, my lord, this appeal has been prepared against the order passed by the learned trial judge on 25th July 2023, page 174 of the stay petition. Here is the, my lord, the
Why
prayer was
approach the court 11 years after your return?
no, my lord, prior to that, my lord, several occasions before this honorable court by filing this writ petition. My lord, facts is this: the petitioner has been appointed initially in the primary schools. Thereafter, my lord, he has been appeared before the School Service Commission and he has been recommended at the concerned schools under the secondary school. Now, he has joined. Soon after join, the school authority, my lord, issued a notice by producing the all certificates to the petitioners.
Where is
And
the
according
DI memo of 24th July 2023? Has any disciplinary proceeding been initiated
no,
against
nothing,
you?
nothing.
So
Nothing
where
has
is
been
the-
done because my lord, honorable my lord justice, my lord Jyotirmoy Bhattacharya was my lord filed this writ petition in 2006.
Huh?
Then 2006, this writ petition has been filed. This is the earlier my lord, trial courts has been order passed. When the date of the retirement, the final order was passed in 2006 writ petition. Whereas my lord justice Bhattacharya was pleased to direct that the school authority is to be, as well as the district schools is to be treated because the MA certificate or MA degree has been obtained from
is the order that
my
has
lord.
been impugned? Where is this DI memo of 24th July?
DI memo.
Last line of the order dated 25th July, first page. Yes, what do you say? Where
My
is
lord,
that, where is that order?
my lord, my lord, I am saying, my lord.
Eh?
My lord, he was appointed.
We are not on that. Where is this order? Do you have that copy?
No.
It's your DI who has
Yes,
passed.
my lord, it is annexed with the writ petition, my lord.
Page.
My lord, that is page.
My beak has been not taken away.
No, no, I am, I am so sorry, my lord.
That is
Because-
because the court is not dismissing the matter. He
Yes.
can come and
My lord-
repeatedly make a prayer before this court.
My lord,
Court is giving indulgence. He's taking advantage of that.
and I requested him to take my Xerox copy of my brief also. I am
My lord, kindly see the page 163 of the state petitions by my lord, letter dated 27 July 2018.
We are asking you one question. Do you have any answer to that? Don't show us other documents. Do you know where is that memo? This 24 July memo, which is referred to in the order, where is that memo?
24
You have filed writ petition was decided on affidavits. No,
No, no,
no,
no.
my lord, because
So,
my lord,
Mr. Chaudhary, you place the
yes,
facts.
I am
before us.
placing, my lord. My lord,
No, you use an opposition to this
my
state.
lord, I think my lord is not my lord maintainable, my lord, because my lord, 88 he my lord got my lord he has been my lord appointed as my teacher at a secondary school.
We are wanting to see the DI memo by which his case was rejected.
My lord, that has been
And
annexed.
you have that copy.
That has been
not the-
annexed. That has been annexed with the my lord stay application.
I have to search out this memo.
Oh, okay,
As
no.
your lordship, my lord, think.
After making such. Yes, call the next one.
After we get
তুমি আমার ব্রিফটা নিয়ে নাও না জেরক্স করে
briefটা দাও আমাকে।
Yes.
সেকশনটা রাখো তো।
চলো বাইরে চলো
So I am for the petition.
Well, in this matter, the other day, I said to produce the answer script. I produced, my lord. Well, well, the third page of the answer script, your lordship, kindly come. That was the allegation of the petitioner.
Yes.
Yes, my lord, kindly see page 45, my lord, the answer
Right, I have
script
produced the
supplied by,
original answer script.
my lord, my allegation is, my lord, the
Page
initial
45.
page 45, my lord, in the stay application, my lord.
Well, at page 3 of the
Yes,
original answer
madam, we
script.
will come to that. Let him finish, we will ask. Page 40.
Page 45.
Yes.
Yes, my lord, the answer is 1.20 last one is for 1.20. This is, my lord, the someone, my lord, the overwriting initially
What
marks.
about 1.11 answer?
Yes, my lord, the kindly see initially marks was granted. Initially marks was granted.
Your initial grievance was 1.11 question has not been
No,
properly.
1.20 also.
Eh?
1.20 also.
No, 1.11 you have nothing else to say.
No, 1.11, my lord, thereafter the given the marks.
1.11.
1 they have, my lord, I have no objection regarding on.
So your only objection that question.
I have challenged, my lord, subject to lordship, I have challenged the four answer, my lord. Subsequently, my lord, the honorable single bench was hold only one question and call for default. Another, my lord, my prayer was, my lord, my marks manipulated.
That was in respect of 1.20.
All marks. My lord, other marks also they have cut down. Initially marks granted, subsequently they decrease. That is, there is a severe allegation. That's why, my lord, I pray before the honorable single bench to investigate the matter. Who done this? That is our prayer before the, my lord, the honorable single bench. But honorable single bench was pleased to direct there is no question of evaluation. My lord, my prayer before the honorable.
No, the report was called for pertaining to which
One question.
So
Only
let us
one
not
question.
go into the others. We
Yes.
are on the
Yes.
question of 1.20.
Yes.
So show us what you are wanting to show.
My lord, kindly see page 45, my lord, the last one, my lord, the someone, my lord, the overwriting, the, my lord, the kindly see the marks is, my lord, the right answer is go. This is the correct answer. Subsequently, my lord, the first examiner, the marks was granted. Thereafter, these marks has been decreased by overwriting this answer. And, my lord, kindly see casing.
Now, what was the correct answer? 1955.
Is the go answer option is not, my lord, 1955. It's the 56. Someone, my lord, the manipulated and, my lord, the given initially examiner when they examine the paper, the marks granted. Subsequently, someone, my lord, it is, my lord, the overwriting and, my lord, change the year and, my lord, the marks has been decreased. So, my lord, who done this? My lord, my question before your lordship, my lord, I putting in, my lord, question myself. If the, my lord, the petitioner given the right marks, my lord, right answer, so first examiner, they have granted the marks initially, subsequently thereafter, this overwriting someone and the marks has been decreased. What again, my lord? 1.11 also my challenge. But
Again, you are going back. We are
no, my
not
lord,
concerned.
why this done? My lord, my total number was granted 15. 15 would be same. For that reason, my lord, this marks has been decreased. My lord, there is the question. My lord, I have given the answer. I got the 15 marks.
In this
So,
history.
This is the one question only. 15 marks has been granted. Subsequently, my lord, my challenge is there. My lord, the 1.20 initially marks has been granted.
So you should have got 16.
Yes, my lord, this is the, my lord, my lord, before your lordship, my lord, if the marks answer has been given rightly and examiner marks has been given rightly, but subsequently thereafter, how the putting the another ink, the change the year and my marks has been decreased. That is the
Lordship, when the coordinate division bench took up the matter, my lord, the query from his lordship was to file a report. The correct answer to 1.20, it is go, but it is 1956. Now this petitioner has written 1955. So the query of the coordinate bench, division bench, was as because she has written go, though 1955 is wrong, but go is right. So why marks were not allotted to him? So I filed a report, my lord, on the other day, my lord. Kindly, the answer is in the report, my lord. Kindly go through the report. The direction by the honorable.
Report affirmed on
My lord, this report is affirmed on
18 July.
18 July. Lordship. Now, my lord, kindly paragraph number 3, my lord. Paragraph number 2 is the query of the court.
No, before that, kindly come to page 45.
Yes,
The
it is in
HPD.
page 45 only. This particular answer, 1.20.
Please listen to what
Lordship, lordship.
from 45.
Hmm.
First, it was marked as 1 plus.
Lordship,
1 plus was marked.
yes.
Then is this paper re-evaluated?
Lordship, no. These all question papers are then checked by head examiner. This is the exam. There are two inks, my lord, are used. That is the reason I was asking your lordship to go to the original answer scripts. My lord, it will be clear before your lordship who have done it.
Let us go one by one. You are showing paragraph 3.
Paragraph 3.
To place that paragraph.
Lordship. Paragraph 3, my lord, the board was asked to disclose the reason for not awarding any marks in question number 1.20 in the said section, said for division.
One line went missing in spite of the
Writing go.
fact that he was given 1 mark previously.
Previously, thereafter deducted. My lord, why deducted? That answer I have given in my report.
Place.
My lord, paragraph 3, my lord, I state that after the said order was passed by Honorable Division Bench, the history answer script of the petitioner was sent to the head examiner of the said subject for his opinion in respect of question number 1.20.
Wait.
রিপোর্ট দিয়েছেন দিদি আমাদের
আগের দিন দিলাম তো নেই তুমি তো রিপোর্টের রিপ্লাইও দিয়েছো আমার
না না
তাপস কুমার হাজরা তোমার মত
না না ওই যে কবে করে এটা
accession to the petitioner's report.
Yes.
My lord, paragraph 3, may I read you, lordship? I state that after the said order passed by the Honorable Division Bench, the history answer script of the petitioner was sent to the head examiner, it will be examiner, of the subject of for his opinion in respect of question number 1.20. After going through the said answer script, the said head examiner has given the opinion where marks could be awarded. If, my lord, why it was not given? If the petitioner had written only in the answer only 1956. That is the correct answer. Written only alternative number of the answer, that is go. Well, either if she has written only go or she has written only 1956. But well, what she has written both answer number, that is answer correctly, that is go and 1956. So, my lord, if she has written go and 56, she would have been awarded the marks. Only go, then also she would have been awarded, or only 1956, she would have been awarded. But
where is this rule?
No, my lord, our answer, but
this interpretation
that is up on the head examiners to decide how to award the marks.
No,
Because
there has to be a reasonability. When the headmaster said that if these 3 options are fulfilled, I would have given it.
But
what basis he is saying?
My lord, whenever the examiner checks the answer scripts, my lord.
Right.
So there are some directives.
Where is that directive? That a question has to be assessed. Either it can give the option as go, or it can say without go 1956, or he has to write go as well as 19.
Because you have to write all things correct.
So where is this? Has there been any indication in the question paper that you have to answer it in this manner?
No, that is not. question paper, always it is written, you have to write the correct answers. If there is a silly mistake made,
So
your
let us
lordship,
see the question paper then.
well, thereafter, my lord, his allegation is,
Allegation will come
no,
later.
my lord, this is one thing, that why marks not given in spite of written go, and 56, maybe 55 may be wrong, but written go, why marks not given? That is a separate question, my lord. I'll come to after. But what his allegation is, that is somebody, he's raising it is very serious nature of allegation.
That somebody has interpolated. I
want to answer to first. Let me answer that, because it is very important. It's a very
then
big
you
allegation.
answered without answering our question. If you
No,
want
but
to answer.
Well, this is a very allegation, your lordship, my lord. That is the reason I have produced.
You are not, don't identify yourself with the board. You are our officer.
Lordship.
We are asking you, first question which we have asked is that these three procedures which is being told by the head examination, on what basis he has said? Was there any directive of the university board that a student, he must be knowing, na? Suppose I am the student. I must know that if I write only go, I will get the marks, because there is no indication in the question paper that I have to write both, or I have to write single, or I have to write in what's the entire language.
Is that really required to write on the answer scripts, because they are supposed
So
to write
you
the
don't
correct
have any.
answer.
So you don't have any provision to show us that this
And
can be.
I don't know whether there is any written directives for the examiners to do that. That instruction I don't have. I have to
Bring that instruction. You bring that
But your
instruction.
lordship, even if there is some, obviously there is some instruction on basis of which the head examiners examine the answer script. There must be some directives. But your lordship, is it? I'm asking a question to myself. It is really required to say you have to write the questions correctly. Because
Madam, it is a question. It is an examination which I am appearing. When in the OA, it is not an OMR sheet that I have to tick mark. It is a question paper where I have to give marks. Column is not provided. I have to say go, then I have to write 1956 to get the correct mark. So when you initially examined, your initial examiner said that even if it is 55, I must give him 1 marks because she has written the correct option, go. Now this decision was altered by you. On what basis?
That is the by the
head examiner. So head examiner cannot proceed without there being any provision.
Then your lordship, the same answer script. Well, the same
now you come to your next.
No, well, in this only I will show. Thereafter I will place that what I
So
was.
this today you have no answer to that.
No, but if my lord, if head examiner does not have the power to decide,
we don't know.
Right,
we don't know.
And what I'm getting, my lord, this is just I'm asking your lordship to myself. If the head examiner does not have the power to decide which answer to be given correct, cut down, or increase, then your lordship, in the same page before your lordship, page 54, question number 1.4.
Page 54.
That same page, your lordship.
Question 1.4.
1.4. Kindly see.
1.4.
Yes, he has been.
Yes, well, here the examiner has given 0. Now the head examiner, after saw that here it is wrongly given 0, marks should have been increased. So he has increased, given it 1.
Yes. Which marking is of head examiner? And
yes, well, for that, your lordship, I have produced the original one. The head examiner, your lordship, the examiner uses pink and the head examiner uses green. That is the reason I was asking, your lordship, finally go through the original answer script. Well, page number 3. 1.4. One per 4, your lordship will find 0 is given by in a pink. And head. Display for your lordship that this answer script contains a lot of overwriting. what is his allegation that someone have overwritten and made it? Well, this answer
No,
script,
that we understood. Your
lot of, I'll display lot of overwritings.
No, no.
Even your lordship, I'll display one.
We accept your concession that this has not been interpolated. This is 1955 was the answer given by the candidate. That is your content. As regards interpolation, we will listen to him. But you satisfy us. First of all, you have no procedure towards re-evaluation of the question paper unless the student applies for review or something.
No, my lord,
Then on what basis this was done?
in every answer scripts, in every answer, in normal process, the answer scripts are by first the answer comes to the head examiner, they distribute to the concerned examiners. After completing those comes before the head examiner. Then in general, head examiner goes in a random way through the each rechecks. Before publication of result, he rechecks.
We accept that.
Yes, it happens, your lordship.
No, we are not saying it does not happen. But there must be some material on the basis of which this decision can be taken by the head examiner.
It is totally upon the head examiner to decide. It is upon the, this is a subjective, my lordship. It is upon the head examiner to decide. Because here also, your lordship, he has written Anandamohan Bosu. Now he decided it should not be given 0. Marks should have been awarded. And your lordship, I will display before your lordship how lenient the examiner and the head examiner was for this particular student, your lordship, because lots of overwriting, nowhere her marks have been deducted, lordship. I'll display in each and every answer.
Acha, is there any other instance except 1.2? Is there any question wherein marks was deducted? You have shown us 1.4 where marks was added.
Yes.
When marks was added, because the go option was correct, name was also correct. Then why it was not marked? Why it was given 0 initially?
The head examiner have done some wrong.
No, not
Oh,
the
no,
head
not this one.
The initial examiner did some wrong. That has been rechecked.
Yes. And initial head examiner also did some wrong with 1.4 also. Because that the student should have got 1 marks, where he had made a wrong and given 0. And your lordship, if your lordship kindly come to question number 3.4, kindly, for my satisfaction, kindly come. Question number 3.4.
Why for your satisfaction?
No, so that I can display before your lordship the overwrite. Your lordship will find. Yes, your lordship will find February 1823 overwriting. Thereafter, your lordship
3.4.
3.4. Answer number 3.4, overwriting. Thereafter, your lordship, answer number 3.9. Well, kindly come. Overwriting. Well, 3.10, your lordship will find Jibone, overwriting. Your lordship found 3.9, 1876 overwriting. Then your lordship 3.10, first Bangla Sangskriti Jiben, maybe, overwriting. Thereafter, your lordship, I'll display lot of. Question number 3.13. Lordship, kindly come 3.13. part of her answer script. But like this is last 1, 2, 3, 4, last but 4 page. There again, my lord, the page before the last page, your lordship will again find the extra page, my lord. Subject she has not written, registration number she has not written. And the examiner have marked, but in spite of that, no marks have been deducted.
All right, Ms. Bhattacharya, you show us that how the marking, how I have to answer a question. Is there any indication in the question paper?
No, it is never in the question paper, the indication, because it is not in that, what is said, OMR. They have to write the answer. They are taught in their school how to write the answer. They give the test examination. They give the pre-test.
The previous examination meetings which were held, that was for the purpose of ascertaining the correct answer to 1.11. That you have satisfied. Our only query is, Ms. Bhattacharya, suppose I am the student, I am given a paper. When we used to suppose options are 1955, features in those 4 options.
No, 1950. Yes, features.
Features in those. Now the correct answer is 1956. But on what basis? Suppose I am a student, I must be aware that how I should answer this question. I have to give the number as well as to correctly state.
Well, may I say one thing? We are taught in the school, when he appeared in an examination, we are taught in the school, my lord. When also we appeared in Madhyamik, even in law examination, my lord, nothing has written on the answer script. We knew because it was taught by our teachers and in our law by our senior students.
That is your perception. That is your perception.
School teachers, my lord, they have even in how the question have to answer, they before appearing in Madhyamik, they sit in the well, if that is so, your lordship, how she answered in others, your lordship? Go and 1953 given the correct answer. So, my lord, she knew about it. Kindly see. Even your lordship 1.12, there also she have written it correctly. Co 1778, and also in question number 1.3, go. She knew about it, your lordship, so she have written correctly all the other answers. Here, my lord, what appears, she had some confusion regarding 1956 or 1955. So she might have written something, thereafter she has overwritten it.
55 is not an option. 55 is not an option.
Not in option. So from where she got 55?
Oh.
No, acha option hai, question paper ta bar kar.
Nee, কোনো option নেই।
So, my lord, how she have written, my lord, she can answer.
So 55 is not an option.
Yes.
One could have understood that if 55 was an option, she was trying to play both, maybe go and the other one. But here 55 is not an option, Ms. Bhattacharya.
Option আছে?
না না নেই।
Well, maybe, my lord, that is her.
The basis of identifying the correct answer to
display. She has made lot of overwritings, lot of silly mistake in the entire answer script, even not writing her name, not writing her roll number, not writing her registration number in the entire answer script, my lord. And she have written, she knew about it to write, because in the others she have written both co and the answer. That is a mistake on her part she had made. And well, we have overlooked lot of mistakes. We are not even deducted a single marks in all the overwritings throughout the answer scripts. And even we have not deducted marks in the extra sheet taken by her, where she has not written her name, she had not written her registration number, not written her roll number.
Correct. 56 correct answer.
ছয় লিখেছিল সেটা কি you wrote 1956, but that was changed as 1955 by overwriting.
Yes, my lord.
No,
This
is
next.
that
This is
your
not my handwriting. Yes.
What is your contention?
yes,
that
that is-
you
that is.
did not write 1955. This you have, so
No,
you
I
left
have
it
not
to
done.
go.
Yes.
Only 1955 was written. That, Mr. Chaudhuri, it is difficult to appreciate. Kindly see it to down original.
Answer script, your lordship will find different ink pen used by the petitioner.
See
And
that
different handwriting
you did not write anything because that first 19 figure which you have put na, that 19 tallies with the other 19s in the paper.
My lord,
It
subject to-
appears, just apply your mind. It may be your contention is that she did not write any year. She only wrote go. That is why she was given one.
my lord,
And this 1955 has been inserted.
subject to
Is this your contention?
my lord,
So,
subject-
Mr. Chaudhuri, kindly see 1.6. See how you write 6. না বলছি আমি গ লিখেই ছেড়ে দিয়েছি easy wrote go.
No, I have written 1956.
So do you find that 6টা কোথায় পাচ্ছ? See 2-3 questions above how you write
My lord,
6.
I'm seeing the question.
That's on the 6th.
6, Mr. Chaudhuri,
It is 1.16,
please tell me
it is
that
different.
6, how you write 6 with that. You write 6 like this. Now that impression is not there in the answer.
My lord, subject to-
Had it been a case that you wrote something, but suppose you wrote 8. 8 is Bengali, 8 is like this. Now, if 8 is changed to 5, interpolation is there.
yes.
Then you can ascertain that this is interpolation. But here, Mr. Chaudhuri, does not seem to be so.
My lord, kindly see casing. My lord,
Hmm?
casing, my lord, top J marks initially granted. Kindly casing portion. My lord,
Pardon? What your
my lord, the casing portion, my lord, top.
aging?
My lord, this is the marks. My lord, subsequently marks, this marks was increased. Initially, I got 15. Suppose, my lord, this marks has been increased. If increased, the 15 will be 16. So that has been same. These marks have been reduced. This is my contention.
No, so how, if it's wrong, naturally it has been reduced. Just because 1 mark was reduced and 1 mark was increased will not,
My
how
lord,
does that help your
my lord,
case?
my learned friend said, my lord, this is
No,
this is
your
wrong.
contention is that answer they gave correct mark.
Yes.
Now they thought that this mark has to be reduced.
Yes.
So let us give 0 in this mark. That is what you are saying.
Yes, my lord, no, my contention is that, my lord, this is overwriting done by the somebody.
তাই জন্য আমার একটা যেহেতু বেড়ে গেল ওটাকে ছেড়ে দিই।
No, lordship, he is saying overwriting done by somebody. Well, why should, what is the enmity of the head examiner with the student?
My lord,
Because well, the question,
one
any
thing
answer
is, my lord,
state
subject to
does not
lordship.
remain in the same district.
Omna,
It goes to other district. Then your lordship,
My lord,
it is very,
one thing is,
why
my
he
lord,
has increased.
there is
Hey,
the
Mr. Bhattacharya, he is not your student. Why you are so? You take your seat now. You have
Only
made
one
your
thing,
submission.
why I am so
Don't.
anxious? That is a very
No,
serious
no.
allegation is given.
You are an officer of the court.
That
Your
is-
anxiety will not be how your client has dealt with the matter. Don't say be anxious about your client.
No.
Be
I think
anxious.
that it has been overwritten. Well, that by the authority concerned. Well, that is the only thing which is troubling me.
My lord, subject to lordship correction. My learned friend, my lord, suppressing one thing.
In
This is
exception,
the
what did you
this
say?
is the my lord, the internal instruction. If the marks will be changed,
No, Mr. Chaudhary, that was not the ground of challenge.
no. But I'm
That has
just
fallen from us.
yes, my lord, just my lord, the internal instruction is there. If any marks will be changed, the examiner will put the reason the why the marks has been changed. This is the internal memo. Well, let them produce that memo. My lord, each every person they changes the marks without giving any remarks. Like there is the some memo is there, but I came to know from the examiner.
This was a wrong word. সেই জন্য এক
So, my lord, JEE, joint entrance examination. My lord,
Oh, I
the
see.
three
So
was
she
this
was-
rank is the my lord, they will take the admission, my lord, in the medical.
Now, Mr.
Sure.
Chaudhary, why you are
My
wanting
lord, this
a
is my lord, the guardian of the my lord, the student is contention is there. Is
Suppose we have to meet your point, na?
yes.
Your contention, your points means the student's version. Student will say there is interpolation.
Interpretation, my lord.
Interpolation, if
Yes.
we set aside that plea, that will be prejudicial to the student. She will be getting a finding contrary to what she has said. Why you are
My
insisting
lord,
on
there
this?
is the rank because my lord, the only 4 marks will be increased. They will be placed in the 10th rank of the West Bengal.
If 4 marks increase,
4
he will
marks
become
I have
3
challenged the 4 marks. They have decreased the 4 marks only. Or kindly see page 47 how the marks has been decreased. Page 47 also.
Yes, you want to show anything else?
Yes, 47, page 47. Yes, initially, my lord, the
এসিটা চলছে না নাকি গরম লাগছে না এই পাখাটা চালিয়ে 47
yes, initially all my lord, this is the map pointing. All my lord, they given the 0. 0 plus 0 plus 0 plus 0. Then 1 plus 1 plus 1 plus 1.
where you are showing
Page 45, my lord, 47, my lord.
Map, your lordship.
Map pointing.
If your lordship takes the original answer script, the difference of ink will be clear with your lordship. And the
No, no, please,
second page of the answer script,
Second page.
original answer script.
But kindly see original answer.
Map.
Map pointing is the
Well, the second page, but that's the second page. First page is this number paging and the second page.
.11. What answer did you give?
my lord, answer initially, my lord, all marks was given 0. 0 plus 0 plus 0. 4 marks is, my lord, the initially granted 0, subsequently 4, then again reduce 3 minus 1, 4 minus 1, 3.
Well, examiner given 0, head examiner
There is, my
increase
lord,
the
some
marks.
putting the, my lord, the
So where marks increase,
reason why the marks has been, my lord, the decrease.
The
My lord, subject to
that
lord,
bill has
my
been
lord,
referred.
1955. मतलब तो kindly मतलब let them to check the मतलब the guidance मतलब
Mr. Chaudhary, you check. Yes, we have told you, na? That is why we were saying we will say something against you.
Yes,
That
yes.
means the student will be suffering. So, what we pass our order, Mr.
Well,
Chaudhary?
one thing I take instruction because that the main allegation is the handwriting is not hard. But that is only
We will
allegation. Yes.
answer your submission. So, the present appeal has been preferred, challenging an order
My lord, may I have your lordship's kind leave, my lord, to appear for the appellants. My lord,
respondent.
this is, my lord, an appeal, my lord, preferred by the, my lord, state, my lord, on the points, my lord, that, my lord, the incumbent concerned who has, my lord, asked for higher scale of pay. I'll just, my lord, in a very nutshell, my lord, I'll just
Higher scale refused.
higher scale refused, my lord. She entered the service in 2005 in the pass category. My lord, the issue is the post that she was appointed in is of a pass category. My lord, she appeared in the examination in the pass category as opposed to, my lord, the examination taken for honors and postgraduate category candidates. So, my lord, her entry to the service is on a different mode, not at par with, my lord, those who are in the honors and pass category, honors and postgraduate category. Now, my lord, the issue, my lord, these issues, my lord, have been dealt with, my lord, some judgments of this court also. But I'll cite those. My lord, the rationale is that, my lord, there is a valid classification so far as, my lord, persons entering into past graduate category is concerned. This is, my lord, the background. And, my lord, the impugned order, my lord, was passed on the
Please place the order first.
my lord, kindly allows me, my lord, page 20. Page 20 of the stay application, my lord.
No, what did the previous bench? It was dismissed initially. Then what happened? Upon cost, it was restored.
My lord, it was restored.
Any stay order was passed?
No, my lord. So, my lord, we are at, my lord, the order dated 16th of April 2024. Kindly see at page 20. So this is the impugned order.
Yes, place it.
Kindly, my lord, sees. Yes, the writ petitioner claims higher pay scale after acquiring of master degree. The issue has already been decided by this court in the matter of Payal Jana Panja versus State of West Bengal and others. The judgment was delivered on July 19, 2023 in WPA 18770 of 2012. Mr. Bhaskar Prasad Boishwar, learned additional government period, appears for the respondents, but respondent 1 to 3 has confirmed this court that the decision rendered in the matter in Payal Jana has not been appealed from, and the same has been acted upon by the authorities. Mr. Vikram Banerjee, learned counsel, appears for the writ petition, draws attention of this court to the application dated January 2, 2006, annexure
No, what happened? Payal Jana was placed by you. It is in
my lord,
favor
they
of
placed it. My lord, the other side, my lord, the petitioners, writ petitioners placed the Payal Jana.
That Payal Jana covers his claim. That
My lord, that is, my lord, the basis on which, my lord, the impugned order was passed. Now, my lord, kindly turns over to page 22 once.
We will go to 22. Finish up with
My
the
lord,
order.
my lord. I am.
Mr. Banerjee appears, draws our attention to the application. What is this application? 2nd January 2006 at page 24 of the writ petition.
For a higher pay scale, my lord, the application was made, which is P4 to the writ petition.
The writ petition has not been annexed.
But it has not been annexed.
Call upon him, let us. Oh, Payal Jana ta অনিরুদ্ধই দি। Yes.
My lord. So, my lord, I am placing the rest of the order. Well, there I'll show, my lord, the Payal Jana order. The writ petition and submits that the petitioner duly submitted her application claiming the higher pay scale. In view of the above, the respondent number 3 shall take the necessary and consequential step to release the higher pay scale and pay the petitioner accordingly, which shall be payable from the date of the application submitted by the petitioner dated January 2, 2006, immediately but positively within a period of 3 weeks from the date of communication of this order. With the above observation and direction, this writ petition stands disposed of without any order as to costs. Now, my lord, kindly, my lord, I request your attention at page 22, which is, my lord, the Payal Jana order, which forms the basis and foundation of the impugned order.
She claimed higher pay scale in respect of which subject?
My lord, physical education. Physical education, my lord, that is a pass category
Physical
post.
education, there is no examination for honors and PG separate.
My lord,
only one examination.
Yes, my lord, and she appeared in that pass category examination. So, my lord,
no, there is no pass category, honors category in respect of physical education.
My lord.
Only one examination.
My lord, my lord.
The differentiation which you made was, suppose in any other subject, suppose I have an honors degree.
My lord.
I apply for the honors PG category.
my lord.
In the physical education, subject to correction by you, in physical education there is no honors PG category.
My lord, I am grateful, my lord. That is my instruction also.
Then to he comes, sir.
My lord, no, my lord, the difficulty is that since there is no honors or PG category, my lord, she appeared in the pass category.
How can you say pass category? This is one category.
Kindly
Whether
see.
it is pass,
My lord,
honors or PG,
my lord,
that is.
the writ petition, my lord, has not been annexed. My lord, the writ petition should be there in the file, my lord.
So you bring it.
My lord, may I file a paper book, my lord, including the writ petition, so that, my lord, it will be, my lord, easier to, my lord, place this document. Because, my lord, it is very relevant.
Contempt.
Yes, my lord. I have filed contempt, but it is not yet been taken up, my lord. Kindly don't pass any order because 7th July 2025, this coordinate bench has directed for department to bring all the writ petitions and previous orders. 7th July 2025. Your lordship see the file. So they have not annexed the writ petition. They have not annexed the other orders also, which was placed before the
like 7th
7th July.
My lord,
Coordinate bench.
7th July.
7th July 2025.
29 July.
My 7th July.
Adjourn.
No, although the impugned order reference is made in Payal Jana, state of West Bengal, it appears as the claim of the writ petition was decided by the learned single judge in the previous writ petition, namely such and such, on 21st December 2012. Ratio laid down in such and such. Amitabh Manna, second writ petition was essentially an execution of an order of 21st December 2012, in spite of the order passed in favor of the writ petition. Authorities concerned were not releasing higher pay scale or higher degree. Mr. Sengupta, learned counsel, that order, my lord. To 7th July 2025. At the bottom, my lord, department is directed to produce records of writ petition number 6547W.
No, what is you preferred for higher pay scale?
Yes, I preferred for higher pay scale.
Then, as that was not given previously, you moved one writ petition.
Previously, my lord, in the year 2006, I moved a writ petition.
2006.
Yes.
Achha, then
that was disposed of in light and observation of another writ. Yes, Amitabh Manna. Amitabh Manna, my lord, entirely covers of the
held in your favor.
Physical education subject.
Achha.
Yes.
What did the single judge say?
Amitabh Manna was held in my favor. My writ petition was also disposed of. Thereafter, allowed.
Achha, then?
State did not prefer any appeal against that order.
Oh.
State did not prefer any appeal. Many persons got. Now, my lord, I did not file a contempt. So this time I again filed a writ petition.
Oh, fresh writ petition for the implementation of the RTR.
Yes.
Then what did
in the meantime, my lord, larger bench judgment has come into picture.
Payal Jana is not larger.
No, not larger.
Utpal Kanti.
Yes. That's 3 judges bench, my lord. Reference has come into picture. Payal Jana was decided by that learned court for getting higher pay scale in botany subject. The ratio of Payal Jana may be, but I did not place Payal Jana. Payal Jana
will not apply. Amitabh will apply.
Amitabh will apply.
That was physical education.
That was physical education. And physical.
Yes,
my lord, I have that.
That is my contention, my lord, subject to my lord what.
Then why
Payal Jana case, my lord, just my lord, because Payal Jana case, my lord, it is regarding, my lord, someone in the honors category, my lord, who is sailing in the same boat with the persons in the postgraduate category.
Right.
So, my lord, there lies the distinction.
Principle is not applicable.
So, my lord, on that foundation, my lord, the impugned order was passed. So, my lord, good, bad, indifferent.
Higher pay scale principle is applicable. Payal Jana subject is different,
my lord,
but higher pay scale principle is applicable.
But good, bad, indifferent, my lord, that is the foundation of the, my lord, order impugned.
Higher pay scale principle is applicable.
So why have you not annexed department ke bole? So department is there produce ei Omlan eta dekho na. Ische file ische. Sir, you go through this issue is covered.
My lord, I follow. My lord, I'll try to apprise your lordship. Otherwise, also, my lord, but on points of law, my lord, but the primary issue is that Payal Jana being not applicable.
Achha, very good. You bring the copy of the writ petition.
Very well, my lord.
You are saying that I will show you show things. Records have already come.
My lord.
So we are not permitting you to file any other application.
My lord, only thing is a paper book, informal paper book to incorporate
those. Space scale power. Informal paper, then we have to stop it. Contempt, do not proceed. He will not get the benefit.
my lord.
You make up your mind and come. You are our officer. You
My
will
lord,
check
of course.
it up and check.
I bow down. I bow down.
If you
I'll come back.
if you say that yes, Amitabh has not been appealed against, issue has attained finality. Moreover, in physical education, Mr. Dotto, kindly check it up. That in physical education there is no such bifurcated examination for pass category and honors category. So as much as I
Very well, my lord. I'll take further instructions on this particular point. If there is any
now with the next Monday.
next Monday. Very well, my lord. Next
Next
Tuesday
Wednesday.
instead.
Next
Very well,
Wednesday.
Wednesday. Grateful.
Mr. Banerjee, give him a copy of Big Amitabh.
Yes, my lord. I will.
If you kindly check it up.
My lord,
If
I'll
you
go through
find,
this.
if you this contention is all right, Payal, on the basis of Payal, his claim could not have been allowed. So that is a ground for asking him not to proceed in content. But when he says we will not be proceeding, you please check up Amitabh Jana
Very well.
and check up Utpal Man. That
Paul Kanti Koron, my lord.
Koran.
That's the
and
big
these judgment.
voluminous judgment. Yes,
So
yes.
after reading, you find that yes, there is a case, you tell us.
Very well.
Otherwise, we will dispose.
Very well. Very well. I follow your order.
Yes, next.
Grateful.
Six. Records reveal that no one appeared on behalf of
I am for the respondent.
দিয়ে গেল হ্যাঁ অর্ডারটা দিয়ে yes
Sir, counsel for the appellant is
item number 7
yes.
yes
Counsel for the appellant is busy in court number 18. His matter is going on presently. Item number 9 and 10.
we are
Moving
also
on.
busy sir, what can we do? We are also busy.
Well, kindly see the
It is defective,
impugn
out of
order,
time.
my lord. Kindly see impugn order, my lord. Nothing in this case, my lord.
You are the sister.
I am
You
for
are
the
the sister. Your brother expired.
no, my lord. I am the respondent. He is the appellant.
আরে বাবা সে তো
Yes,
বুঝলাম।
yes.
Alpona Kaur is the sister of the deceased.
Sister, my lord.
So DCRB the sister is entitled to family pension.
No, my lord.
Then
So I
you are for the
state, my lord.
state.
Yes, my lord.
হয় না তো? Sister is not an elder brother now. Sister has approached mandamus. Sanction of pension fund garnishment working is governed by DCRB. As per DCRB, after the death of a teacher, there is no provision sanction for that. So, কি আছে আর মামলাটা? Nothing in this matter.
Mr.
হাঁপায় না, বসো।
Short pass.
DCRB you have 81 DCRB ঢাল নেই তলবার নেই নিধিরাম সত্য এখানে আমাদের আছে না ডিসিআরবি স্কিমটা
তাড়াতাড়ি কল করুন আমি ছিলাম
got back the breath.
My lord, my point of appeal is only 2 points. My lord, in this, it is admitted fact that in DCRB scheme, in a pension category,
এখনো হাঁপাচ্ছে বসো বসো তুমি কি করছো মা ডিসিআরবি রাখুনি তোমার যেহেতু পেনশন হোল্ডার নয় সেই জন্য তো
জাজমেন্টটা নিয়ে বলছি কি? মির্জা শিকদার খোল।
Yes, Mr. Ghoshal. Here,
Ghosh, Lord.
Ghosh.
Lord, the order impugned what has been passed,
Right, right order.
rightly, but
তাহলে আর
Lord, but the thing is this, Lord, the sometime, Lord, the social for social justice.
এটা পারে না।
Lord, kindly consider this aspect, Lord, the I will satisfy your lordship, Lord,
Dissatisfied করে। He doesn't come under this scheme.
but
Sister cannot get pension for expiry of
I have
mother.
considered the DCRB rule 26, Lord,
সব জানে
that is
না।
there, Lord, but despite that, when there is a blood, otherwise I will be ill suited. I have no remedy, my Lord. I will be remediless.
না না রেমেডি থাকলে না রেমেডিলেস হবে। You must have the remedy না। You don't have that can't. Where DCRB, where is the definition of
Lord,
remedy?
when there is a blood exceptional circumstances, my Lord can exercise the jurisdiction. Lord, I am showing one judgment, Lord, the kindly see, Lord, where the exceptional circumstances arises. Sumita Sikdar, DCRB
You have filed your section 5, exceptional circumstances. Huh?
section 5, no.
The delay to.
No.
Huh?
Lord, the section 5 application is filed regarding delay. Can one, Lord.
এতে কিছু নেই গো। এই যে for purposes of family pension, wife, husband, minor, unmarried, minor daughter, dependent parents. Unmarried. Other, neither in the family definition nor in the
Lord,
entitlement for family pension.
Lord, regarding that, the trial court, honorable single judge rightly passed the order because my remedy is not regulated under this statute. Lord, but my respectful submission was there before the honorable single judge. Lord, this is the exceptional circumstances. The exceptional circumstances is that the concerned teacher was an unmarried, and I being the sister, I am also the unmarried. We are depending upon each other, Lord.
Have
And
you challenged the DCRB?
DCRB not
তাহলে
challenged.
then now we could have applied the ratio of unmarried daughter.
It ought to
Special
have
bench
been,
judgment.
Lord, it ought to have been.
তো সবই জেনে শুনে আর করে দিচ্ছিল এ কিছু নেই উইথড্র করে নেবে
এখানে নিচের করে
No, we can allow your section 5.
Lord, 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 kindly direct the trial court,
No,
concern,
Mr. Ghosh, you can do this.
consider my
It will
application.
not prevent. What consideration?
What?
You yourself, you are saying it is not that you do not know. You understood. Ashok, the present appeal has been preferred challenging an order dated 12 Come with a better case. Come with a better. Acha, what happened to your that matter? You got the benefit.
My lord, everything.
Appeal.
Sure.
No Supreme Court.
No, my lord, by consent order was passed.
Then, no, initially there was
There was a contest. Thereafter, my lord, the intervention of your lordships, lord,
they
both
got the money.
your lordship directed both the parties to file the affidavit.
Next matter.
Service. Lord, I am for the petition.
Before your मोटा brief क्यों देखे?
Lordship's manner reference this.
ये पूछो ना गया तो मोटा brief
My
क्यों
lord,
देखे?
issue is, my lord, these petitioners are
सुनचे ना? ऐतो मोटा brief क्यों देखे?
only and it will some. From the memo, my lord,
Tell us what is.
my lord, facts are, my lord, admittedly petitioners, my lord, are pursuing B.Ed qualification. My lord, B.Ed is an essential qualification for appearing in the examination, my lord, for 9, 10 and 11, 12. 9, 10 examination, my lord, already over, my lord. 11, 12 is on 14. My lord, the case of the petitioner is, my lord, according to the regulations, my lord.
ওটা নিয়ে যাও না। তুমি check করবে।
According to the regulations, B.Ed examination is of 2 years and it has to be completed by June of that particular year, the last semester. My lord, what happened? The last semester of our in our university, where the petitioners and we did, my lord, taken admission, Baba Saheb Ambedkar University, they have not completed it. As a result, when the advertisement was done, my lord, could not complete the B.Ed examination. We approached this court, my lord, seeking that kindly allow
Examination process. In
my lord,
which
B.Ed.
In which you were enrolled as B.Ed candidates.
I was enrolled pursuing B.Ed candidate, but the university did not complete it within the time stipulated.
Huh.
As a result, my lord, when the School Service Commission initiated the process
When was
on
that?
30th of May 2025, this year,
Oh.
this second SLST, we approached this court saying, kindly either
Treat us as B.Ed pass.
treat it as B.Ed pass. If we ultimately our 4th semester is we do not qualify, cancel our candidature, because after 9 years the examination is being conducted. Many of us will be aged by the next.
Everybody will come. That I am a student. If I
understand, my lord, but here, my lord, the difference is we have already pursuing and only the 4th semester is left. Last semester is left.
How can we give?
My lord, I understand,
legal
my lord.
right?
This is
You show us any legal right, we'll give the benefit.
my lord. Only
But
thing I can
all
quote
right.
your only thing I can rely upon your lordship, my lord. A similar
So
situation.
suppose today we say that you give them, allow them to participate. When you are participating, one person, if you become selected, again you have to come to the court, seek the permission to be appointed.
No, my lord. In the meantime, they have advertised that examination will be conducted by finished and conducted by November. They have advertised. Baba Saheb Ambedkar has advertised. My lord, only thing I can rely upon, my lord. Recently, my lord, the same issue cropped up in primary recruitment, and it went up to the Supreme Court. What happened, my lord? A session of 2020 and 22 training batch was not completed within the time. Those candidates approached the High Court. The training was not completed within time. The board has initiated an advertisement. Kindly allow us to sit. The single bench allowed us. Division bench rejected it, and it went up to the Supreme Court. Ultimately, when the Supreme Court directed, no, you consider they have already now passed. You keep those. You have already reserved vacancies for those. You conduct and appoint them if they come within the zone of consideration. This is a judgment, my lord, I can rely upon. But to be honest, my lord, the issue was not decided whether a pursuing candidate
No, Mr.
can.
Dasu, to tell us, if you do not fulfill the eligibility criteria on the date of the advertisement,
I have no right, my lord.
Admittedly, I have no right.
Then how
But
can we?
considering this is one thing that I do not have a qualification, and in my case, my lords, because of the authorities, I could not have the qualification. This is the only difference, my lord. Nothing else, my lord.
So you did not place that judgment before his lordship?
No, my lord. I was not, my lord. There, my lord. It was not placed.
ও আচ্ছা।
আরে ওই 2022 ওই মামলাটা
Now that filling up of form is already over, no?
filling up of form I was
Long-
not
long
allowed,
time.
and 9-10 examination already over. 14th is the examination for 11-12, which we can also.
And we don't know, my lord, whether all the appellants are eligible for 11-12 or not also.
No, they are eligible. Otherwise,
Now how can you, because you have not yet obtained B.Ed,
yes.
No.
then
That
how can
except
you
that
appear
huh,
for the
except that B.Ed. Otherwise, I am qualified. I have post graduation, and
B.Ed is not a
Mandatory qualification.
it's a mandatory. It's mandatory.
then Mr. Dasgupta, how can you?
No, that is the.
Oh, you mentioned that day.
On their minds, my lord. Because after 9 years, this is happening again. After how many years, nobody.
Supreme Court.
কিন্তু issue not decided.
তাহলে কি হবে? দুষ্টু করছে অল্প। অল্প দুষ্টু।
বুঝতে দিয়েছিল ultimately.
শুধু একজনের।
মেমোটাই
The present appeal has been preferred. Hmm? Hmm? Who
I am
is
for
your
the I am for the
correspondent?
respondent lead petitioner. Only thing is that on the similar issue, another appeal has been fixed by your lordship on 23rd of this month. Now the issue in this writ petition is whether the writ petition is maintainable against a delegating school or not. This is the only issue. Now that single judge decided in my favor that the writ petition is maintainable against the delegating school, relying on the St. Mary's and other judgment. And
The issue is not only that.
23 তারিখ শুনবো।
The issue is not only that.
No,
That
we
is
will,
one of the issues.
we will hear on 23rd, Mr. Chakraborty.
I have no difficulty. If my learned friend says he is convenient on 23rd, I can.
this is the
23rd
number. This is
23rd
the number of the appeal which was fixed by your lordship on 23rd.
No, if you give the number, ওই নাম্বারটা 23 তারিখ আসবে বলছে।
If my learned friend is appearing in that matter, then
Yes,
let him
yes,
serve
yes.
copy of that matter so that I can be assisted with.
He can also, he is a party to that.
No, no, no,
Not
no.
a party, but I do not know. He says that it is
It's a
same.
different school. Mr. Badi is appearing for the school.
Lord,
In that Mr. Badi is appearing.
Yes.
Same issue involved.
Same issue.
Lord, if he says that only DA getting school, then my appeal, Lord, is beyond that. It's beyond that. It's not only DA getting
Acha,
school,
what
because
did
DA
the-
getting school issue.
What did the court say? What benefit court has given you?
In this matter,
Huh?
in this matter, single judge decided in my favor that the writ petition is maintainable against the delegating school and the direction for affidavit is there.
Oh, direction for evidence.
Yes, yes.
So we keep the maintainability point open, Mr. Chaturvedi. Let the single judge decide.
Lord, two things, my Lord, has been done by the learned single judge. My Lord, one, that a writ petition is maintainable against DA getting school. That, my Lord, is hit by the Supreme Court decision in Trigun Chandra Thakur. We say that merely because it's a DA getting school, that would not permit a writ petition to be maintained against it. There must be a public law element. The second, Lord, the learned single judge relied on Marwadi Balika Vidyalaya, saying that the order of termination passed by us, I'm sorry. Was an order of termination and realization of salaries, my Lord, that we have paid to the teacher because the appointment has been fraudulently obtained. Thus, realization part has been stayed, and insofar as maintainability part is concerned, my Lord, it has been held that I am a DA getting school. Hence, on that anvil of receipt of DA, the writ petition is maintainable, notwithstanding the fact that it relates to a disciplinary proceeding. So two issues, one DA getting and another, even in the realm of private law contract, writ petition is maintainable. This is, my Lord, against, my Lord, the ratio of Marwadi Relief Society, my Lord, upheld in the very recent decision in Army Welfare Education Society's case.
So on the issue of maintainability, you want to use any material, or it is there in your writ petition?
Yes, yes. In my writ petition and the judgment of this Supreme Court and as well as.
Let it appear on 23rd. Let us see what will happen. In course of hearing,
Army welfare citation টা বলো।
বলে দিচ্ছি।
we have been informed by the affidavit service
Item 10 is identical.
Item 10 তাহলে ওই সেম অর্ডার করে দিও সেম ইউ আর অ্যাপিয়ারিং না ওনাদের নামগুলো দিয়ে দিও the next matter you are there
Item number 10, I am for the state.
oh Mr. Boysu
So I will.
yes
Item 11, I appear on behalf of the appellant.
who is
And I appear for the writ petitioners.
I appear on behalf of
state
I appear on behalf of the appellant.
appellate
Now I have
I am appearing for response number 6 and 7.
ওরে সর্বনাশা
I have
you will have a difficult time now. Mr. Choto, you are not there in this matter. Mr. Bhattacharya is, you are not. Mr. Boisho is also not there. So he will be having an open field.
The Lordship knows better to be lucky.
Lord, there are a batch of writ petitions which have been filed before the learned single judge as well as before the Honorable Supreme Court with regard to obtaining admission and obtaining registration. Now, my lord, the Parent Act, which my lord deals with the matter, is the National Commission for Homeopathy Act 2020. Now, my lord, I find that so far as the matter is concerned, my lord, I could, my lord, get the copies of the orders which have been passed by various honorable judges of this honorable court, wherefrom my lords will be pleased to find that, my lord, I am just showing two orders to my lords. Kindly come to page 59 before showing to my lords the impugned order and to why I have preferred this appeal. Kindly come to page 59. Lord, this was an order, my lord, which was passed by an honorable single judge. My lord, I'm just indicating to my lords, my lord. The petitioner is a homeopathic medical college. Petitioner wants to admit the students in BHMS course who have not qualified NEET. Petitioner relies upon an interim order passed by the Delhi High Court in WP number such and such. It has been submitted on behalf of petitioner that various orders, that various high courts have passed different interim orders permitting the students who have not qualified NEET to take admission in the course of addition to the qualified candidates. Mr. Dhol, learned advocate appearing for the petitioner, places reliance upon a judgment reported in 1995, supplementary 1 SCC 461, to argue that though the interim order does not create any binding precedent, the need for uniformity in the exercise of judicial discretion requires that all similar matters should receive the same treatment, except where factual differences require different treatment. Kindly note this thing, Miller, this is very relevant. Mr. Bhattacharya, learned advocate, appearing for the respondent number 2 and 3, submits that the appeal preferred against the said interim order of Delhi High Court has not yet upon been heard by the Honorable Supreme Court. It has been submitted that since sincere efforts are being made for an early hearing of the appeal and the matter is running in the list of the Honorable Supreme Court. Now, Millard, I come to the operative portion. In view of the judgment of the Honorable Supreme Court in Vishnu Traders Supra, I am inclined to pass the similar interim order as passed by the Delhi High Court in WP number such and such, and accordingly, I allow the college to admit students in BHMS course for the academic year 22-23 with the net qualified students at the first instance. If the seats are not being filled up by the NEET college qualified students, then the college will be at liberty to admit students who have not qualified NEET but are otherwise qualified to pursue the BMHS course in terms of the applicable regulations. In the admission letters, the college will indicate that the admission of the students are subject of the outcome of this. Now, my lord, I should draw to my lord's kind attention, this is my, my lord, duty as an officer of the court, that I should place section 14, my lord, section 14 says...
What is the matter about? This is a 2022 order. You're showing...
This is a 2022 order. I am
What
showing
has
to
the single judge?
my lord,
Take
the
us to
order of
the
the
order
learned
of the
single
single
judge,
judge
the order
first.
of the learned single judge, my lords may kindly come to, my lord, page, this, in my memorandum of appeal, my lord, I have annexed it, and page, first page.
Now, who are you?
We are also the students. We are similarly
situated with
similarly
the writ
circumstanced like the appellants. The writ petitioners,
Then
respondents.
what order did they get?
Right. Now kindly come to, that's the reason I'm showing to.
No, you first take us to the order, then.
Yes, I'm sorry, my lord.
Place the order.
Yes, I'm sorry, my lord. I'm just showing to my lord. কত পাতা আছে?
Page
My lord, the impugned order is at page 2. Yes. This is an order dated 18/8/2025. আমার কথা তা নয়, এখানে আপনি অ্যানেক্স করেছেন? হ্যাঁ, এই অর্ডারটা করেছেন, সেটা দেখান।
Page 12.
Page 12.
Page 12 of the application.
Miller, page 12. I stand wrong, Miller. Page 12. Page 12. Your lordships may ask me that why you have preferred the appeal.
Please place the order.
Yes, Miller, I'm placing the order.
Petitioners
The
are
petitioners are pursuing the Bachelor of Homeopathic Medicine and Surgery course at the Nitai Charan Chakraborty Homeopathic Medical College and Hospital. The respondent number 6 herein, a college recognized by the West Bengal University of Health Science. The respondent number 4 herein. Miller, pausing here for a moment, I should say that admission is given by the National Council of Homeopathy, and Miller, the registration part is being given by the concerned university.
No, we have not given yet.
The petitioners are alleging that the university is unnecessarily denying the registration in the said course. What I told you, lordship.
University means the
West Bengal University of Health Science.
West Bengal University of Health Science.
No, they are pursuing Bachelor of Homeopathy.
Yes.
In Nitai Chandra Chakraborty College. A college recognized by West Bengal University.
Yes.
Very good. Now the petitioners
All
are
the
alleging.
colleges, my lord, subject to correction of my lords, they come under the ambit of the particular, my lord, the university, my lord, which is known as West Bengal University of Health Science.
Yes. Now what happened?
Now, my lord, kindly see why. Yes.
Petitioners are alleging.
Yes, petitioners are alleging that the university is unnecessarily delaying the registration of in the said course. So far as we are concerned, yes, I'm sorry, Miller, I'm sorry. Mr. Devopriyo Gupta, learned advocate for the National Commission for Homeopathy, the respondent number 2 herein submits that the petitioners are not even qualified in the NET as such. Their admission in the respondent number 6 college is wholly illegal. He further submits that on the self-same issue, here is my case. He further submits that the self-same issues that are pending writ petitions being WP number 13413 of 2025, WPA 112287 of 2025, WPA 14656 of 2025, WPA 15352 of 2025, and WPA 15809 of 2025. Now, pausing here for a moment, I should say to my lords, that all these writ petitions are not identical and are not based upon the self-same issue. Now, my lord, your lordships may kindly consider why.
Please.
Yeah, I proceed. I proceed.
No,
Yes. The learned advocate for respondent number 6 college submits that the college has also filed a writ petition being WPA number 26738 of 2023, which is pending. Let all the above mentioned writ petitions be listed along with the present writ petition on September 11, 2025 under the heading motion. The respondent number 4 is directed to cause an immediate inspection to respondent number 6 college to ascertain whether there is any student in the said college who is pursuing BHMS course without having qualified the NET, and to file a report before this court on the next date of hearing.
So why do you want leave to appeal?
Yes. Now, Millard, the reason is that so far as the writ petitions which they have in which the learned single judge had indicated
are not identical issue, are not
that's right.
So how this order has prejudiced you?
Suppose
You are viewer?
we are the students of the college.
Yes. So
we are the students. Now, Millard, we have raised different
so
issues.
you also have not passed NEET.
No, we are
So
we
you
are
are
sailing in
similarly
the same
situated.
boat like the
Situated
appellants.
at the
Appellants are
but the,
appellants.
it is an interlocutory order, my lord. The writ petition is pending, my lord, and due to be listed on 11 September, my lord.
11 September. Okay.
I only want that the writ petitions be heard separately and distinctly. I do not want anything else.
Tell that to the learned single judge.
Millard, that's a reason. But your lordship may kindly consider, having regard to this observation, the learned single judge will proceed that this is on only on one issue. That is that
you were not there when this order was passed. So you raised this issue when the matter is taken
May I
up on
say
the-
one thing? My lords may kindly clarify this much. I don't want anything else. I am not, whatever order is there.
Unless we allow your leave to appeal, how can we pass that order?
Yes, that's a thing, my lord.
Mr.
We are not, we have not been made parties. We are sailing in the same boat. And now, Millard, supposing, Millard, I say, Millard, kindly consider one aspect of the matter. I have what I did, I told my learned junior, Millard, he obtained all the orders. He obtained all the orders from the Supreme Court, all orders of the Supreme Court. And the Supreme Court, my lords will be.
Why we are going there, Mr. Bhattacharya?
No, I am not. I know that. I know that this is.
Then why did you file this appeal?
No, I filed only this appeal to the extent that these petitions, my lord, we decided this.
Have you filed any? Is any one of the writ petitions mentioned there? You are parties.
Yes.
In the writ
yes.
petition.
The writ petitions in which writ তুমি যে মামলা করেছো তুমি কোন writ petition এ পার্টি কোনটা বলো 11287 of 2025.
Very good. This is a mere submission.
14656.
This is a mere submission on his part.
Yes.
That there are similar writ petitions pending.
Yes.
So on that date, if the matter goes, any order is passed which is contrary to your interest,
yes,
then now you can come and file the leave.
May I say one thing? May I say one thing, Millard? Your lordship may.
So what is how you have been prejudiced by
Millard,
this order?
I am only prejudiced to the
There
extent.
is no order. This is an appeal.
Millard, there are two things. Millard, there are two things. Kindly consider. One is there is an observation of the court that there will be an particular Millard inspection.
How that prejudice you?
No, I am only on the point. I am only on the point. Let there be an inspection. But although Supreme Court, Millard, I have your lordship may, Millard, kindly bear with me for.
No, why should we bear with you, Mr. Bhattacharya? When we find this order does not prejudice you in any manner.
Millard, this order has prejudiced me to the extent. This order had prejudiced me to the extent.
Yes, to the extent?
To the extent that although my particular writ petition involves various issues, but these cannot be clubbed up together and
Who
cannot
has
be heard.
clubbed it?
Millard,
Who
kindly
has clubbed it?
Millard, kindly consider. Millard, I may be wrong. I may be wrong.
Submission has been made.
Millard,
has the writ court clubbed that?
Yes. Millard, kindly see.
Has the writ court said all the yes, will be.
Millard, kindly see this observation.
This observation. Go and tell the learned single judge.
Millard, I say, Millard, that supposing, Millard, there is an observation of a learned single judge. Kindly, I say nothing. I say, Millard, because the appellants and we are sailing in the same boat. I have nothing more to say, but only I say that let the writ petitions be heard and decided independently. That's all I say.
No, why are you assuming, Mr. Bhattacharya, that they will not be heard independently?
No, why? Because your lordship.
The learned judge has said, let it all appear in the list on the same day. There is no direction for analogous hearing.
Kindly see.
Yes, I've seen.
Millard, I submit. Kindly consider, Millard, the second and third paragraph of the second page. If I am not wrong.
The third paragraph is the only bit. Let the above mentioned writ petitions be listed along with under the heading motion. That's all.
Therefore, Millard, what happens is when a batch of writ petitions are coming up to my lords, your lordship may kindly consider that primary matters, your lordships are hearing out. Now, Millard, when a batch of these matters are coming, your lordships are, Millard, deciding the main issues. This is my only contention.
This is a misconceived conception.
I say, Milord, kindly consider this thing, Milord, that I cannot be, when I am not a party, if the learned single judge would have given a direction that this matter will be heard, and supposing it would have been heard, nothing
So
prejudices.
who is preventing you to appear before the single judge on the said date and say that you delist my petition because it is not a case?
Milord, I say, Milord, once a observation and or a direction is passed, once a direction and or kindly consider this thing, Milord. I appeal to my lord that
You tell us what we will do. You tell us that we will allow your leave to appeal, and we will say the learned single judge don't proceed.
No.
Then what do you
saying
want?
that. For a second, I am not saying
So
that.
then what we will explain that. So we
must
have
take
to
a
say,
very
Mr.
pragmatic view.
Bhattacharjee,
I must take a pragmatic approach. I cannot say that the learned single judge will not proceed with my writ petition. No, never. But I say.
So what do you want?
I equally say that all the writ petitions.
Case that without getting an opportunity to tell the learned single judge that my writ petition is different, the learned single judge has clapped down the matters and taken up. Had that been a case, Mr. Bhattacharjee, we could have interfered.
That is also a case. We have been prejudiced. This has been written in the memorandum of appeal.
So that you have to tell the single judge, na?
Milord,
Without
kindly
telling the
consider.
single
Milord,
judge, can you say I will prefer leave to appeal against this?
No. I say only I have also prayed, kindly see in my stay application, that kindly modify the order to that extent. I don't say anything else. Modify the order to that extent. Otherwise, Milord, these observations, Milord, may be fatal for me.
What observation has been made that
whatever may be, the issues may be hard and decided separately in the writ petitions.
So that how can we say you have to apprise the learned single judge?
The learned single judge will say then that I have not preferred an appeal against it.
Not required.
Therefore, there
matter
is only one issue.
It is not a case of addition as a party in that matter. You are having an independent writ petition double one.
That's right. But when these have been clubbed on the basis of the submission,
clubbed means you will not be allowed to appear.
Milord?
When it is clubbed, judge will not allow you to appear for your.
No. I am not saying that the judge will not.
Then what is your apprehension?
My apprehension is there will be only one issue which will be decided. But there are different issues. And Milord, there are, Milord, if your lordship, Milord, kindly takes my stay application. Milord, for a second, I show to my lords. Milord, kindly see from page 15. Page 15 to 58. Different judgments have been pronounced by the Supreme Court, and thereby permitting the students to appear in the examination.
Take this point there.
This will be very difficult on my part. I can appeal. I have nothing more to say.
The present application being
application can number to then be
dismissed.
Application can number can number ki
না ক্যান দিয়েছে ক্যান 1 আর 2 চিঠি থেকে হ্যাঁ 1 and 2 ওয়ানটা কি ওয়ানটা লিখি আর কি লিখি সেখানে কিছু লেখা নেই ব্ল্যাঙ্ক
The present application being can Next.
Miller, the affidavit of service will be kept on record. No, I say Miller, this thing why?
What evidence, sir?
Sometimes it happens. That Miller, your lordship.
Mr. Bhattacharya, if you
views of
if
the
you
courts
come
are
and tell
different.
us, if you come and tell us that this court, though there is a direction, all the appeals will appear, but my lord, my appeal is different from that appeal. Why should we not listen to you? You are apprehending that that will become binding. That is why we mentioned that argument of yours is misconceived. That is why. Yes, next.
I'm grateful to my.
Appearing for the School Service Commission.
The secretary for the
For the appellant, not a challenge.
We will pass that order.
Only one line that you can consider one. But Sonali Das matter, the Honorable Supreme Court pleased to grant liberty to the SLP petitioner to move before this Honorable Court to decide whether CPT attended candidate or not. But I pray if you all to let my requisition be pending to that effect all. Regarding my prayer, particularly in interview process, your lordship has already said this. I don't want to say that. But regarding whether I'm tainted or not, a declaration is required to be.
Sonali means which one?
Reference to kindly come to page 118 of my act.
118?
118.
Yes.
If granted, perusal of the impugned order reflects that the High Court was of the opinion the requisition filed by the appellant, Sonali Das, did not warrant consideration on merit, owing to the judgment of this court in state of West Bengal versus Boisakhi.
Oh, we have dealt with this in our order. Have you seen our order?
Yes, absolutely.
We have dealt with
I'm only saying that since the Honorable Supreme Court has granted him liberty, granted her liberty before the High Court to decide whether she is tainted or not. On that point, may be kept open for my case.
So we have kept that point open.
But your lordship, my petition has been dismissed.
Read petition has been dismissed, but we said that this was the argument advanced that in Sonali, Supreme Court has said that the issue of tainted, untainted has been left to be decided by the learned single judge. But they, in that case, there are factual differences in that. We said that that will not inure to the benefit of the appellants to obtain an order for participation.
I'm not saying on the part because I also challenged their decision to treat me as a tainted in my petition.
Acha, we order
May I place?
This is the order, Miller.
Well, I am taking leave, Your Lordship.
হ্যাঁ কোথায় পালিয়ে যাচ্ছে
কোথায় চেক করছো যে তোমার
Where are you going?
না লিভ দেন লিভ রিজেক্টেড
হ্যাঁ
মানে লিভ রিজেক্টেড
14 মামলা ধরেছে
14 থাক না লিভ রিজেক্টেড
Must to say in this matter, Your Lordship, SSC is the answering respondent. Yeah, I can.
কি ভুল বললাম কি ভুল বলেছি
The second last paragraph, my lord, of your lordship.
Such courage to say. But you also kindly come to the
এই যে সোনালী দাস we have referred. Mr. Mojumdar senior advocates adopted arguments of Mr. Lairi. In view thereof, this court has jurisdiction to consider the said issue, which is your argument. We have recorded that, and then we have ultimately said.
Second last paragraph.
The order in Sonali Das was passed by the Supreme Court. And subsequent thereto, the commission had submitted this. That does not mean we have stopped you. We don't have the authority to stop.
My prayer is that if you also dismiss my requisition has been dismissed, if you also kindly make my requisition pending, thereby rejecting my interim prayer for interim order.
No, you file fresh petition. Mr. Ghosh, how? Because today, if we allow the writ petition to proceed on that, then our observation in the earlier order becomes negated.
Because I have paid the same, I have paid prayer for my single judge to declare that I am not a tainted.
That you are apprehending, Mr. Ghosh. If a fresh writ petition filed and is dismissed on that ground, then you can come and tell us Supreme Court kept the point open. How can the learned single judge on the basis of this order cannot entertain my writ petition? Then we will come here. The same order to pass.
I paid for declaration that I am not tainted. My writ petition, I prayed that I should not be treated as a tainted.
আচ্ছা সেটা লিখে দিচ্ছি
That may be.
Other facts and everything are right. we can veto this order.
Yes, sir. Only on the point that the sense I have made.
Lord, these submissions, my lord, was not made before the learned single judge, my lord, that they are seeking declaration or that they have similar facts to that of Sonali Das.
Just one.
Yes, yes, that has been paid.
How will that prejudice you? Line, his submission will be there. Drawing our attention, Mr. Lairi, on Mr. Saraj, we have habeas corpus matter has been sent by the Supreme Court to.
I thought this matter will continue for some time.
We cannot take up your matter today. Okay, do we keep it after the vacation? You are there, no?
I will take my ballot.
No, not your matter, not your matter. এই ওইটা একটু লিস্টে দাও একটু আগে না আগে অ্যাপেলেট সাইডের নাম্বারটা বসাও অ্যাসাইন গুলো আবার চেঞ্জ হয়ে যাবে অ্যাসাইন অ্যাসাইন অর্ডার শিট তোমার অর্ডার শিটটাও বের করো দেখো তো একটু চেক করে
টাইমটা টাইম শেষে আছে
My lord, the other day, my lord,
just one
apologies.
ওইটা তো একটা অর্ডার লিখে we have extensively heard the learned advocate. এগারো তারিখ ফার্স্ট ডে তোমার রাইট আছে on 11th on 11th November as fixed at 2 p.m.
What appellate থাকে না origins
The matter shall be treated as heard. The same order appellate side Kartik. You have a interim order is there till end of 11.
origins side appellate side both matter.
Yes, we are keeping it as parted so that we
yes.
can. তারিখ দুটোর সময়
But that is that essential commodities matters are adjournment.
The Mr. Bandyopadhyay, we have kept it after vacation on 11th.
No problem is there is no interim order man.
In your matter there is no interim order. In the appellate side matter
That is there. That's
আর এটাতেও আছে কি পাঠাট করা আছে অ্যাপেলেট সাইড না অ্যাসাইন টু দ্য
appellate side also make the parted.
27শে মার্চের অর্ডারটা একটু দেখাবে এটাতে পাঠাট আমার দাও আমি দেখে
But it was not made parted.
Yes, Mr. It has been made. We will so both are parted before us. No problem.
Yes, all right. Great.
ওইটা শুধু বলে দেবেন, we have extensively heard the learned advocates and respective studies. ওই পাঠার পড়াই আছে।
Give your place to us. Give your place. But I filed an impeachment application last year. I told your lordship that may I give my appearance.
Give the number.
Can 3. It is running in the list.
It is there along with the matter. You apprise us on that. Yes, Paul.
At the very outset, lordships, I would intend, Millard, these two matters, Millard, they were directed by the Honorable Supreme Court, Millard. At 50 will be heard, Millard, without going into the merits, Millard. It was said that if my lord can be
Hard without going into the merits.
My lord, what had happened, Millard, while the other set of matters were being taken up by the Honorable Supreme Court, it was mentioned in course that writ petition number 50 and other similar matters are pending before this Honorable Court, which has no bearing upon the writ application which is pending before the Honorable Supreme Court. So in the course of that understanding, the Honorable Bench said that those matters which have no bearing with the matter which is pending before the Honorable Supreme Court may be taken up by my lords. So, Millard, there is no such direction, Millard. So now why I am pointing this out, Millard, that, Millard, we had taken a preliminary point on maintainability as well as on other issues of maintainability, including, and now another issue we are joining now, that is under CPC Order 2, Rule 2. Because, Millard, the second writ petition, which was withdrawn during the pendency of the writ petition, which is pending here, Millard, which was challenging the deportation order, has been withdrawn without any leave.
Millard, I am appearing for respondent number 1 to 4. Mr. Trivedi will advance his argument for respondent number 5 and 6. Millard, I apprise your lordships that Mr. Prashant Bhushan before the Honorable Supreme Court brought it to the notice of the Honorable Judges that the matter which is pending before your lordship is the habeas corpus petition, and that matter has nothing to do with this. But the Honorable Judges of the Supreme Court were not apprised. There are 2 writ petitions pending at Delhi High Court. And they apprised their lordships to decide the citizenship issue, which is not the subject matter before your lordships at all. The citizenship issue is not the subject matter. The subject matter is simpliciter habeas corpus. So therefore, we have taken a preliminary point to the maintainability of these writ petitions in our affidavit. Now I am pressing one after the other points. Now kindly see the first writ petition of Bhodu Sheikh.
Just a moment. So we can take up the matter now.
Yes, no problem.
But he said something else.
But why I am saying, Millard, only one point, Millard. My lord may take up the matter, but Millard, as if my lord so directs me to argue on merits, because Millard, because what I understood from my learn.
We have already explained on the yesterday also. We said
yes, Millard.
Madam.
Yes, Millard. I have learned that. Millard. But what my predicament is, Millard.
Give you further time because
no, Millard. I am not. I am just informing as my lord's officer, Millard, that the affidavit which have been exchanged is only on point of maintainability. So if my lord's.
Well, that is what exactly for respondent number 1 to 4 I am trying to submit.
Well, I did into 5, Mr. Trivedi.
Millard, because of the rigmarole of events which took place during the pendency. My lord, what was happening is, Millard, that the writ at last occasion, when your lordships were in session of the matter, the writ petition before the
talk with him. If they give consent, we adjourn the matter. What is our
my lord? We are opposing it, my lord. On the last occasion when the matter was taken up by this honorable court, they took time, my lord, taking this plea. They intend to file, my lord, their affidavit in opposition. My lord, they're raising the question of merit.
Sure. This is the objection.
That was my lord.
From the bar, my lord, we are always, my lord, opposing because that is our duty. We are creatures of.
No. On the last occasion, I appeared and took specific points of maintainability.
No evidence.
Not on merit.
That I have mentioned it, my lord.
No, one affidavit has been.
Yes, so for the maintainability question, on the last occasion, 10, 7, 8 days after the Supreme Court order, my lord, they took time that we are going to file, my lord, the affidavit. So far the merit is concerned. Yes. Yesterday, my lord, I mentioned it. Today itself, up to today.
Yes. That you have already said that on the main matter we will use an opposition. But that has not been used.
So, my
Supreme
lord,
Court has said that you immediately hear.
yes, my lord, that being the situation.
So we have to hear it.
Yes, my
But Honorable Supreme Court has said that my lords
We
may
can
hear it.
interpret that order.
My lord, I'm the last person to do that, my lord. I stand corrected. If my lord will kindly not take me amiss.
Please
But my lord,
apply
what
the-
I am trying to my prerogative, my lord, I am saying, my lord will decide the maintainability. If my lord, as far as that is
No,
concerned,
we will hear maintainability as well as merit. We will not further.
my lord, mirrored,
when
we
the
are not
Supreme
having, my lord, the documents on record.
Can be done. Then on the basis of
My lord,
there I have a special.
on
There I
record,
have a special.
on merit.
There, my lord, I have a specific objection.
My
If
lord,
my lords hold
in a
that
court,
the writ petitions are not maintainable, then there is no question of deciding it on merit.
Then you talk with Mr. Trivedi. You are saying something online. Mr. Trivedi is something offline.
No, Mr. Trivedi is trying to say that the question of maintainability has been exhaustively taken in the affidavit in oppositions, both by respondent number 1 to 4 and by the Delhi police respondent number 5 and 6.
Yes.
So therefore, kindly allow me to address on the question of maintainability.
We are not stopping you. We will hear you. But the thing is that whether after hearing you, we can continue. If we find it is maintainable, we will continue with the main hearing. This much is sure. Now you argue on the main matter, you have to make your arguments today. That is what we want to make clear.
Milord, may I just make one prayer?
Mr. Chakraborty, this is the direction of Supreme Court. Your counsel was also there. Other side is opposing. We fixed the matter. Yesterday, court was, you took a resolution. Now the matter before
Supreme Court, Milord, has requested your lordships to hear out the matter, but that does not exclude our prerogative to take the preliminary point of maintainability.
Yes, argue on that.
Yes. Now kindly come to the first writ petition of Bodhu Sheikh.
Why you are appearing online? You cannot come here and argue. Matter
No,
was
because of my predicament, I'm diamond spondylosis, cervical and lumbar spondylosis.
He apprised you, Mr. Chakraborty, that we want to
So
hear.
if your losses do not want me to appear on online, I shall not appear.
We wanted for convenience sake for you to appear offline.
No,
and
if you are asking me to appear before your lordship, even if I am down with cervical and lumbar spondylosis.
That we have not been told. If you are sick, you argue online. We are not stopping you. It would have been convenient had you been there. Yes.
Now kindly come to the first writ petition of Bodhu Sheikh. That is writ petition number 50 of 2025.
Yes.
Now kindly see what are the array of respondents in the first writ petition.
Mr. Chakraborty, you are appearing for whom?
Respondent number 1 to 4.
And who is your junior in the matter? Mr. Trivedi?
Mr. Kumar Jyoti Tewari. Kindly see in the first writ petition, respondent number 1 to 6. Respondent number 1 is Union of India, Ministry of Home Affairs, address is at Delhi. Respondent number 2 is Government of National Capital Territory of Delhi, address is at Delhi. Respondent number 3 is the address is at Delhi. That is Antika Anand, IAS District Magistrate of Delhi. Respondent number 4 is Monish Chandra Bharma, Subdivisional Magistrate, Delhi. And these respondent number 5, Deputy Commissioner of Police, Rohini Police District, New Delhi. And respondent number 6, Station House Officer, Delhi. Therefore, all the respondents, male respondents are of Delhi. Now, this writ petition has been moved on the ground that a representation was made to the concerned officer. Kindly come to the representation. What is the prayer there? That is representation. Your lordship will kindly find that in page 33 of 6 July 2025. This is addressed to the Station House Officer, New Delhi, at page 33. Now, what is the prayer in the representation? Kindly come to the last paragraph at page 35. Last paragraph at page 35. Has your lordship got it?
Yes.
Page 35. Has your lordship got it? Bottom last paragraph.
Yes, got it.
I therefore urge your immediate and coordinated intervention. Should no satisfactory response be received within 72 hours, I shall be constrained to seek appropriate remedies before the Honorable High Court of Delhi. There was a consistent stand taken by the petitioners is of a cause of action at Delhi. Respondents are of Delhi. Representation at Delhi. Number one. Number two, the latest view of the Supreme Court is about the even if on consideration of Article 226(2), the cause of action, if it arises in Delhi, no writ petition is maintainable. I shall be placing that judgment first. And at page 35, they have categorically stated that action has been taken at Delhi about deportation. Therefore, kindly mark the date of the representation, 6 July 2025. Admittedly, after the deportation on 26 June 2025.
Yes.
Therefore, my lord, I am placing now about this issue of territorial jurisdiction, the latest view of the Supreme Court on the question of maintainability of a writ petition where the cause of action arose outside the territorial jurisdiction, whether it is at all to be maintainable or not. The reference is 2023 volume 7 SCC page 791.
Yes, give us judgment.
Please hand over, Mr. Kumajyoti Tewari, my learned junior, please hand over the judgment to the honorable judges.
It went into some other.
Well, has it been handed over to your lordship, the judgment?
Yes, just now.
No, this is there, the case arose, the cause of action arose at Goa, and the writ petition was filed at Sikkim. And exhaustively it was argued, and the High Court allowed the writ petition and quashed the order, even if there was no territorial jurisdiction. Supreme Court deprecated this and said the writ petition is not maintainable because even if on consideration of 226(2), cause of action arose elsewhere. You know, that your lordship will kindly find from paragraphs in this judgment, from paragraphs 12 to paragraph 21. Exhaustively, this has been dealt with by the honorable judges of Honorable Justice Ravindran Bhatt and Honorable Justice Dipankar Datta on 2023 volume 7 SCC page 791.
13 to 20.
We are wanting to all the paragraphs.
Because there the question of fact and of territorial jurisdiction has been discussed in detail. That is why your lordship will kindly look into.
Place it, place it, place it.
Yes.
Place it.
In para 12 onwards, I am placing.
Place it.
In support of territorial jurisdiction of the High Court to entertain and try the writ petition. This is what the petitioning company has stated, that this Honorable Court has jurisdiction to entertain the said writ petition as the cause of action arises in Sikkim only. Both the petitioner and the respondents are located within the territorial jurisdiction of this Honorable Court. Apart from these two sentences, nothing more has been averred in support of territorial jurisdiction of the High Court. From the above, it is clear that according to the petitioning company, the cause of action has arisen in Sikkim only, meaning thereby the whole of the cause of action and not part of it. Additionally, it is stated that all the respondents are located within the territorial jurisdiction of the High Court, which is factually incorrect. While dealing with an objection as to lack of territorial jurisdiction to entertain a writ petition on the ground that the cause of action has not arisen within its jurisdiction, a High Court essentially has to arrive at a conclusion on the basis of the averments made in the petition, memo treating the contents as true and correct. That is the fundamental principles. Bearing this in mind, we have looked into the petition memo number such and searched in vain to trace how at least part of the cause of action has been pleaded by the petitioning company to have arisen within the territorial jurisdiction of the High Court. Possibly their lawsuits were considering 226(2). Now, para 15. This is a case where clause 2 of Article 226 has been invoked by the High Court to clothe it with the jurisdiction to entertain and try the writ petitions. The constitutional mandate of clause 2 is that the cause of action referred to therein must at least arise in part within the territories in relation to which the High Court exercises jurisdiction when writ powers conferred by clause 1 are proposed to be exercised, notwithstanding that the seat of the government or authority or the residence of the person is not within those territories. Para 16. The expression cause of action has not been defined in the Constitution. However, the classic definition of cause of action given by Lord such and such, that cause of action means every fact which would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of the court, has been accepted by this court in a couple of decisions. It is axiomatic that without a cause, there cannot be any action. However, in the context of a writ petition, what would constitute such cause of action is the material facts which are imperative for the writ petitioner to plead and prove to obtain relief as claimed. Now, I need not trouble your lawsuits on the rest of the paragraphs. Their lawsuits were of the view that the cause of action arose at Goa, the writ petition, no cause of action arose at Sikkim. Their lawsuit first the proceedings allowed the appeal of the Union of India, holding that the cause of action did not actually arise at Sikkim. And similar is the case. There is no single averment in the writ petition except lodging a diary, even if that inspector has not been made a party in the writ petition. Entire cause of action arose at Delhi, number one. Number two, the question of suppression of material fact. Question of injunction.
Maybe ask a question. Is it your contention that had he been deported from Calcutta, then only our court would have had the jurisdiction?
My lord, on the given facts of this case, I shall come to that. They were detained in Delhi.
To you, Mr.
Yes, exactly. Had they been detained in Calcutta, the cause of action could have arose.
Technically, jurisdiction would have been.
And this cause of action will have to be decided by your lordships on the question where cause of action arose.
Yes.
Now, apart from this particular judgment, your lordships will kindly appreciate what is the case made out here before your lordships. It is simpliciter a habeas corpus petition. No citizenship ground has been prayed for, nothing has been pleaded. And that apart, it is a fact which is brought to your lordship's notice by me on the earlier occasion that they have suppressed the material fact of pendency of two writ petitions before Delhi High Court One is habeas corpus petition. The other is order and writ petition challenging the deportation order. So if, my lord, with great respect to your lordships, I submit that on suppression of material fact and a conduct, this writ petition is to be dismissed with exemplary cost within the interpretation of section 41 of the Specific Relief Act. Conduct has to be considered before granting any relief, either interim order or otherwise. And section 41 says no writ petition, no petition shall be maintainable if there is an alternative remedy. Section 41, H and I of the Specific Relief Act. Now, my lords will kindly come to the question of suppression of material fact. There is no
problem. What is the alternative remedy, Mr. Chakravarti?
Alternative remedy is Delhi High Court. To pursue the cases at Delhi High Court, where cause of action arose, not at Calcutta High Court.
We have understood your contention. We are asking you, is there any alternative remedy available to a person who had been deported?
They are to challenge the order of deportation before where it has been done.
Very difficult.
That they have done at Delhi High Court. They have done at Delhi High Court. Writ petition was pending.
We understand that contention of yours, that the alternative remedy ought to have been he should have gone to Delhi High Court.
Exactly. That is what I am trying to submit.
Yes, which he actually went, but he suppressed the material fact and came before us. This
Exactly. Exactly.
We are asking you on merits whether and deportation order is applicable under any provision under your statute.
The order of deportation is passed under the Foreigners Act 1946 and the relevant regulations.
1946 Act has been.
Now, that your lordships will kindly appreciate on the given facts of this case. I am coming to that. I shall not take so much of time. I shall just formulate these questions.
Yes.
Lord, this actually, even if the question of deportation has been made, is there any whisper against such deportation by filing documents that they are not deported to Bangladesh, they are staying in India as well? Is there any affirmation before your lordships? They have accepted the deportation since 26 June 2025. To this date, not a single affidavit has been filed before your lordships that they are not residing at Bangladesh. Even if deported there, they have come out of Bangladesh. They are residing in India. Nothing.
Mr. Chokri, yes.
They are in Bangladesh. They are arrested.
Now you have returned.
No.
That is what Mr. Chakravarti said. Mr. Chakravarti, will you repeat your last argument as regards?
Last argument was as such, my lord. I said that Specific Relief Act section 41 provides for grant of relief, injunction or otherwise. There is a clause in 41H if there is an alternative remedy, number one. Number two, I is the conduct, if it is bad, no relief can be granted. This is the submission I have made. Now, what is the conduct of the petitioners? They suppress the material fact that 2 writ petitions are pending before Delhi High Court. On suppression itself, the writ petition is liable to be dismissed on exemplary cost. Thirdly, your lordships are taking up a question of habeas corpus, which is the prayer. No other prayer has been made subsequently in between. Now, after the order of deportation and filing a writ petition before the Delhi High Court challenging the order of habeas corpus and subsequently withdrawn, And thereafter, during the pendency of these writ petitions before your lordships, the order of detention challenging that writ petition is also withdrawn. Whether cause of action at all subsists, whether at all any cause of action subsists to entertain this writ petition of habeas corpus. Now, your lordships will kindly consider one very important thing in this matter. Now, admittedly, the cause of action arose at Delhi. They were detained at Delhi. They were taken to the community center. They were examined by the FRRO. They were deported on 26 June to Bangladesh. And that is not been denied in the affidavit in reply. In the reply which they have filed. And this is the specific case that they have been deported on 26 June. Now, they have not said and brought it to your lordship's attention that they are Indian citizens. They have come back from Bangladesh and deciding India to maintain a habeas corpus petition as well.
Yes.
Now, your lordships will kindly appreciate this fact that your lordships, as of today, therefore, my lord, the respondents are at Delhi, the representation is at Delhi, prayer is for moving at Delhi in the representation, and that apart, my lord, surprisingly, however, the question of their deportation is also even if admitted in the reply. There is no whisper to challenge this deportation even before your lordships, and the writ petition is simply limited to page 18, their prayers. Kindly come to their prayer, page 18. Page 18 of the first writ petition, my lord. My lords, what is their prayer?
First writ petition means WPA 50.
Bodhu Sheikh. First writ petition, which is, my lord, appearing in your lordship's cause list. Bodhu Sheikh's petition.
In this Amir,
That is separate.
WPA 50, no, millet. Same issue is the same, millet.
But different persons, sir.
Yes. Now, lordship, kindly allow me to place the prayer at page 18 of Bodhu Sheikh's. Prayer A. This is a prayer for habeas corpus. Prayer B for certiorari relating to the steps taken by them since receipt of the petitioner's representation. And this representation is also at Delhi. Prayer is to move a writ petition at Delhi in the representation. Therefore, in view of the prayer made and the amendment in the writ petition, this habeas corpus petition has become infructuous.
Why, you are showing us prayer A.
Prayer A and B at page 18.
Yes.
They read in the nature of habeas corpus, directing the state respondents to immediate production of the petitioner's daughter, son-in-law, and minor grandson, namely such and such, before the honorable court, and release him from the illegal detention of the respondent authorities.
Oh.
So how this writ petition, this prayer is maintainable now on this given facts and cause of action?
So this
admitted case, they have been deported at Bangladesh.
No,
There cannot be any habeas corpus upon the state of Bangladesh. And this is your lordship will kindly consider upon a given consideration and a detailed scrutiny of their particulars when an order has been passed by the FRRO for deportation. Whether this order of deportation not being challenged now in so many words, or before it has been withdrawn from Delhi High Court, whether any subsisting cause of action survives. The Delhi High Court, as I understand and given to understand, has not granted them any leave to challenge the order of deportation. And unless leave is granted, entire proceedings subsequent thereto shall be barred within the provisions of Order 2, Rule 2 and Order 2, Rule 3 of the Code of Civil Procedure. And this, even if the Delhi High Court could have granted them leave, that leave could not have any retrospective effect. That could have been a subsequent event for a prospective effect to challenge the order of deportation. Now, my lord, I am bringing to your lordship's attention to an old constitutional bench judgment of the Supreme Court, where this issue of deportation, consideration of the question of citizenship have all been detailed, considered in detail. This is reference is 1961 SCC online Supreme Court page 2. This is a constitutional bench judgment. 1961, a very short judgment. 1961 SCC online Supreme Court page 2, corresponding 1961 SCR page 744, and then another corresponding AIR 1961 Supreme Court 1526. May I just read, my lord, for your lordship's convenience, a very short judgment where their lordships had been pleased to consider this Foreigners Act and other issues, the question of deportation and all this. But I'm just reading. I'm reading from the very beginning for your lordship's kind consideration, because I shall not take more than 10 minutes now. My juniors are there to assist your lordships. This is a judgment of Honorable Justice A.K. Sarkar, and this is not a dissenting judgment. It is accepted by all honorable judges sitting and accepting the judgment. Now, may I read? Has it been handed over to your lordship, the judgment?
Yes, yes.
Now, Justice A.K. Sarkar, this is an appeal by the Union of India from a judgment of the High Court of Punjab allowing the respondent's application under Article 226 of the Constitution for a writ, quashing an order made against him on January 29, 1958 under Section 32C of the Foreigners Act 1946. That order was made by the Chief Commissioner of Delhi and was in these terms. The Chief Commissioner of Delhi is pleased to direct that Mr. Such and Such, a Pakistani national, shall not remain in India after the expiry of 3 days from the date on which this notice is served on him. The order was served on the respondents on February 3, 1958. The respondent did not comply with that order, but instead moved the High Court on February 6, 1958 for a writ to quash it. Now, para 2. The High Court observed that there must be prima facie material on the basis of which the authority can proceed to pass an order under Section 32C of the Foreigners Act 1946. No doubt, if there exists such a material and then the order is made, which is on the face of it a valid order, then this court cannot go into the question whether or not a particular person is a foreigner or, other words, not a citizen of this country, because according to Section 9 of the Citizenship Act 1955, this question is to be decided by a prescribed authority, and under the Citizenship Rules 1956, that authority is the central government. The High Court then examined the materials before it and again held in the present case there was no material at all on the basis of which the proper authority could proceed to issue an order under Section 32C of the Foreigners Act 1946. In this view of the matter, the High Court quashed the order. It was contended on behalf of the Union of India that Section 9 of the Citizenship Act 1955 had no application to this case. We think that this contention is correct. That section deals with the termination of citizenship of a citizen of India in certain circumstances. It is not the union case, nor that the respondent that the latter citizenship came to an end for any of the reasons mentioned in that section. The reference to that section by the High Court for the decision of the case was therefore not opposite. That section had no application to the facts of this case. Now, para 4. Section 2A of the Foreigners Act 1946 defines a foreigner as a person who is not a citizen of India. Subsection 1 of Section 3 of that Act gives power to the central government by order to provide for the presence of the continued presence of foreigners in India. Subsection 2 of Section 3 gives express power to the government to pass orders directing that a foreigner shall not remain in India. It was under this provision that the order asking the respondent to leave India was made. Therefore, the decision of the FRRO was upheld by their constitutional bench judgment. Number one. Number two, which is very important now, the question of decision of citizenship by the writ court. What the lordship said. Kindly come to that particular portion. Paragraph 6 or no. Section 9 of the Act is one that is relevant. That section, so far as its material, is in these terms: if in any case not falling under Section 8, any question arises with reference to this Act or any order made or direction given thereunder, whether any person is or not a foreigner, the onus of proving that such person is not a foreigner shall, notwithstanding anything contained in the Indian Evidence Act, lie upon such person. So, with great respect to your lordship, I submit, where is the affirmation in the writ petition? The onus is upon the petitioners to prove that they are Indian citizens. The Supreme Court Constitutional Bench has categorically said this. The next paragraph, it is quite clear that this section applies to the person's case, and the onus of showing that he is not a foreigner was upon the respondent. The High Court entirely overlooked the provisions of this section and misdirected itself as to the question that arose for decision. It does not seem to have realized that the burden of proving that he was not a foreigner was on the respondent and appears to have placed that burden on the union. This was a wholly wrong approach to the question. The question whether the respondent is a foreigner is a question of fact, on which there is a great deal of dispute, which would require a detailed examination of evidence. But nothing else to be read in this judgment, which squarely covers our case. And where is the averment that they have come back to India from Bangladesh because they are Indian citizens? Till more than 2 months, nothing has been done by them. Now, Lord, kindly come to my affidavit in opposition, what point I have taken. A very short submission I shall make.
Opposition to
that there are list of dates are very important. These people were detained on 25th June. Before that, they were deported to Bangladesh deportation on 26th June 2025. And 26th June 2025, they were deported to Bangladesh. That is the admitted case of both sides.
No, where are you reading, Mr. Chakraborty?
No, I'm submitting now. I'm submitting.
No, opposition.
They were deported. I'm coming to opposition. Only 2-3 paragraphs. Now this we have detailed in paragraph 8 of my opposition of Boduse's case, WPA number H50 of 2025. In para 8, what are the powers vested under the Foreigners Act to the FRRO? That your lordship will kindly find at para 8 of my opposition. Miller, internal page 3 of the opposition. Internal page 3 of the opposition.
Just one more. 46 Act has been repealed.
No, it has not been notified.
Huh?
Has not been yet notified.
Not been notified.
Your
Notified.
Immigrant Foreigners Act has been notified.
Notified.
4th April 2025. Madam, wait. There are two more seniors to you. Take your seat. The Immigrants and Foreigners Act, please correct us if we are wrong. This was notified on 4th April.
Immigration and Foreigners Act.
4th April. See left, right hand side top. Your notification date, Mr. Tiwari.
4th April.
So 4th April contains section 36. 36 says repeal. Read 36. What a correct us if we are wrong.
Absolutely, these three acts were repealed.
Repeal. Now your contention is that repeal has not been notified.
No. So far as this.
This has been notified. You have framed a SOP under that also. No, we are. This is from the website. From the website, you will.
We have taken an instruction a lot. They are saying it has not been done.
No, Mr. Tiwari, kindly check up.
Page 4th April.
Notification is there, and you have said that your power has been exercised under section 29 of that act. New act.
Deportation.
His deportation power order was passed referring to Foreigners Act.
Yes.
But in your affidavit, you have said that section 29, the head constable went. See the definition of that? The head constable went and intercepted the persons. That he can do under section 29 of the new act, subject to be corrected by 26. Subject to be corrected.
Kindly takes page 58 of our opposition.
We will go to that. Mr. Chakraborty is arguing, advancing the argument on the basis of this act. So we wanted to point out this.
Just give us 5 minutes.
Yes, Mr. Chakraborty.
Yes, I shall come to page 58 later. Kindly come to the. I have said in para 8 of page 3, the power of the FRRO, not only to take action under FRRO, this Foreigners Act, there is also a mentioning of the other acts, which is entry into India, page 3, entry. Under section 5 of the Passport Entry into India Act 1920, under Rule 2 and 4 of the Passport Entry into India Rules 1950, and then for registration of foreigners Rules 1992. But in any case, on application of question of law in a given case, with great respect to your lawsuits, I submit that it is to be done on the basis of the facts of a case. What is the facts pleaded? What is the relief sought for? And whether the relief is at all permissible in a given situation. So yes. Now only two more points. My lord, your lordship will kindly come to. I have already submitted the constitution-based judgment. If the issue of citizenship is raised, that's a serious question of dispute, question of fact. It requires a lot of evidence and all that. And that apart, kindly come to the question of deliberate attempt to create cause of action in West Bengal by lodging a diary after deportation.
Page, Mr.
That is, and unfortunately, if that diary has been lodged at Pakur in district Birbhum, the inspector.
Where is that statement, Mr. Chakraborty? Diary lodged.
That Mr. Tiwari will apprise your lordship. The diary is paragraph.
Diary is of prior to that.
No. Diary after deportation, admittedly. Admittedly, after deportation, the diary has been lodged here to create a cause of action here.
6 July.
6 July. Deportation 26 June.
6 July. Page 33 of the petition.
Diary has been mentioned in the affidavit in reply.
That's
the representation before the SHO Delhi.
It was a missing diary.
No, however, this is a given fact. Mr. Chakraborty appearing for petitioner will satisfy your lordship when the diary was lodged.
Yes,
Whether
yes.
the inspector against before whom the diary was lodged was a necessary party. He is not made a party. Only district magistrate Birbhum is a party here. Therefore, this entire writ petition is misconceived, malafide. And not a single document has been placed before your lordship that they have. I am asking a question to myself. I am asking a question to myself with my some experience in the profession. That after stating so many things before Delhi High Court in two writ petitions, one habeas corpus and the other challenging the deportation, and third petition before Calcutta High Court, whether this petition is maintainable at all, even if those petitions are withdrawn. There cannot be any retrospective cause of action subsisting before Calcutta High Court. And this habeas corpus petition has become infructuous. On the very first day I submitted. Kindly come, my last submission, page 49 of my affidavit in opposition. Page 49 of my affidavit in opposition, Bodu 6. The fact of deportation is not disputed. This was brought to the notice of the Honorable Judges of Delhi High Court at page 49 of my affidavit in opposition. Reform respond number 1 to 4.
Yes.
The last lines of page 49. Status report has been submitted in both the matters which is taken on record. It also contains the deportation order dated 24th, I am sorry, may not stand corrected, 24th June, 2 days earlier, 24th June 2025. Where is the escape of the petitioners from these amendments, from these findings, from the operation of question of law? And lastly, my lord, lastly, I am just taking your lordship's attention, bringing to your lordship's attention, Mr. Tiwari, if it is required, he will place the entire order of deportation with reason how many persons were deported. It is not that Milord, only last is the Annex C which was filed before Delhi High Court is not that these 6 people are deported. There are a list of several people who are deported. Now these petitioners' name appear from serial number 61 to 65 that they are deported by order dated 26 June 2025.
It is 24th June, Mr. Chakraborty.
No, 24th June is the affidavit finding of the Delhi High Court, but the order was passed by the Foreigners Regional Registration Office on 26 June in detailed order, giving all those names of those who are deported.
Where is that order?
That order, Mr. Tiwari will hand over to your lordship.
No, kindly come to page 58 of your affidavit.
Yes, 58 that they shall be retained in the community center till deportation order is passed.
This is 24th June.
Yes, 24th June and 26th June is the deportation order.
Where is that deportation order?
Deportation order could not be annexed because this was done within a very short time. The affidavit, Mr. Tiwari can hand it over to your lordships. That is not denied. This is not denied anywhere in the affidavits that there is no deportation.
Mr. Chakraborty, how they will challenge if they have not been given the copy also? Deportation order has not been given to the writ petitioners. How do we
No, may I ask a question to myself?
Challenge the deportation order, and which was withdrawn without any leave to challenge it before this honorable court. That is my case, and that has been done. Subsequently,
they have challenged the deportation order in Delhi High Court.
Has been passed by the Honorable Delhi High Court on 12/8/2025, where they have challenged the deportation order. Suppression, my lord, at Gullo.
May I just ask only one question to myself?
না পেজ 46 এ কোথায় ছিল?
Second prayer, to take legal action to order to deport the deportation without verifying the valid documents.
এই রিট পিটিশনটা this page 46 read petition, Mr.
My lord will kindly see to the affidavit if my lord
Read petition was filed on 9 July.
lordship. My lord will kindly see that
9 July
second writ
says-
petition.
You are saying that deportation order was under challenge.
Yes, my lord, I'm coming, my lord. My lord will kindly oh, no, wait a not. My lord will take up my affidavit, page for তোমাদের affidavit. কোনটা এইটা?
Deportation order কথা এখানে বল।
Page 46, my lord, if my lord takes up, my lord will kindly take up page 46 of the affidavit. The prayer portion of the writ which was affirmed on 9/7/2025.
7 produce করলো এদের কথা বলে
তারপরে 24 June, 26 June.
এই অর্ডারটি reported on 26 June. The order of 24
এটা হচ্ছে order 24 June. Next question.
Page 46 prayer B. Kindly see page 46 prayer B of the writ petition filed before the Delhi High Court challenging the deportation order.
Next question, জানতো। It's part of the writ petition.
order, not the deportation. The deportation has been by virtue of this order. That has not been annexed. এটা হচ্ছে ডিপোর্টেশন অর্ডার 26 শুধু ওদের নয়
আরো অনেক
দলবল পাঠিয়েছে exercise of power under section this is also
একটু জিজ্ঞেস করে ওরা বলছি যে এখনো ওরা বুঝতে পারবে
yes Mr. Chakraborty.
The last submission I am making subject to what your lordship will say.
What we will but not here.
Last sentence, one line.
Had you been physically here, we would have told you.
But I am not in a position. It is my pleasure to appear before your lordship. I am down with cervical and your lordships are aware what is cervical and lumbar pain.
Unless we see you, we do not get active.
My lord, actually, I was not in. I am taking painkiller and regular physiotherapy to get rid of this pain. My lord, kindly last submission is that in a given situation on appreciation of the facts of this case and in view of the fact that after deportation on 26 June 2025, the present writ petitioners did not come back to India, nor did they raise any issue that their citizens they shall settle in India. Whether in such a case the decision of the FRRO for the sovereignty and integrity of the country can be called in question in given situation of this particular case. The writ petitions should be dismissed in limine on the question of sovereignty, integrity, and national security of the country. It's not a question of Bengali-speaking people being deported. It's a question of Malafide attempt to enter into India, migrate, infiltrate, which is the problem of India for the last 30 years. These are my submissions.
Where is that?
If it is required, my lord, Mr. Tiwari will apprise your lordship.
Chakraborty, in the order of deportation, that is 26 June 25.
Yes.
That where is this national interest was disclosed?
It's not required to be disclosed. It has to be presumed. Sovereignty, integrity, and security of the country. That is the object of the Foreigners Act, the Passport Act. The object of the enactment of these acts.
This Foreigners Act of 1946 is no longer there.
Even if not there, on a given case, on the Passport Entry into India Act and the Citizenship Act, whether a person without a valid passport or a visa can stay in India, there is a penal provision attracted under the Passport Act. Therefore, below, these are my submissions.
Yes.
May I have losses kind leave?
Yes.
Granti.
Identity state. An inquiry shall be conducted by the state government. এবার এই ইনকোয়ারিটা কতদিন চলবে? It must be completed within page 59 plus 7 59 plus 7 এ আরো বেশি বলা আছে। State government having borders contiguous with shall also hand over illegal Bangladeshi to the officer designated after completion of inquiry and capturing biometric and demographic details. Next, in emergency situation, after inquiry is completed, এটা inquiry time নিতে হয়। যেন হচ্ছে যে আমি প্রমাণ করবো করে আপনি একটা মাইগ্রেন্ট হয় আমি আমার পেটের দায়ে অন্য স্টেটে গেছি উচ্চ কিসের বেসিসে একটা ইনকোয়ারি বলে সাপোজ ডিপোর্টেশনটা 2 দিনের মধ্যে তুমি পাঠিয়ে করে এবার সুপ্রিম কোর্টের সামনে এটা স্টেট দি অর্ডার অফ ডিপোর্টেশন এখানে তো ডিপোর্টেশন হয়ে গেছে সেটাই করতে হবে সেটাই কর্তব্য সেলফিশ ফান্ডিং কেন একটা হচ্ছে রাইট অফ অফিসার আর দ্বিতীয়ত হচ্ছে দেয়ার ইজ নো অ্যাপ্লিকেশন they have admitted কি হচ্ছে
My lord, we will clarify, my lord, with regard to the notification. My lord, my lords have, correct. My lords have got that. I'm from Delhi police, but this particular what has fallen from my lords, it is going to affect me also because I am the person who has made my inquiries and then after that. If lordships kindly take up what my lords had laid my lord's hand, that is Immigration and Foreigners Act 2025 downloaded from the internet. Lordship will kindly have, I don't have a spare copy, my lords may. My lords will kindly see on the top, after the date 4th April 2025. Lordships have seen it. It is said, my lord, the following Act of Parliament received the assent of the President on 4th April 2025 and is hereby published for general information. It did not come into effect or force on that day. For general information, now my lords will kindly come to the preliminary thing. My lord, the notification, my lord, my lord, I'm abhi confused mat karo. My lord, that internet notification, my lord, which my lords have. My lord, the following Act of Parliament
Yes,
received the assent of the President on 4th April 2025 and is hereby published for general information. So, my lord, may I? General information, it has not come into force. I'm clarifying, my lord. Then, my lord, will kindly come to Chapter 1, Preliminary 1. This Act may be called as the Immigration or Foreigners Act. It shall come into force on such date as central government may, by notification and official gazette, appoint. Now I'm coming to the official gazette notification. That has been done, lordship, as late as on 1st of September. So, my lord, on the day when this action took place, this was not implemented into lordship. That particular notification is dated 31st of August 2025. SO number published on SO number 3981E in exercise of powers conferred under subsection 2 of section 1 of Immigration and Foreigners Act 2025. The central government hereby appoints 1st day of September 2025 as the date on which the provisions of the said act shall come into force. Now, my lord, reading the Foreigners Act, the old one, a new one, my lord, if my lords kindly see section 36, subsection 2, it says repeal and saving, my lord. 36, my lord, may I read, my lord? 36 2. My lord, the notification which, my lord, I'm handing over. My lord, because we also updated ourselves impromptu, my lord, when the questions fail, because we were told, my lord, but my lord, impromptu, my lord, so my lord will kindly not take us amiss, my lord, render unqualified apologies. Now, 36.2, my lord, if I may be allowed to place, my lord, notwithstanding such repeal, anything done or any action taken or purported to have been done or taken, including any rules, orders, directions, instructions, regulations in any proceeding made or issued or taken or given, and any penalty or fine imposed under the repealed act shall, insofar as it is not inconsistent with the provisions of the act, be deemed to have been done or taken under the corresponding provisions of this act. Now, my lord, so this was done when the old act was in force. This was done, my lord, in the month of June.
So very good. What does the old act provide under that section?
My lord, that will, my lord, as far as the other, my lord, just on this, I'm clarifying, my lord. My learned friend is appearing, just I was clarifying that notification, it fell impromptu. And my lord, that is on merit, my lord, which I was.
Your case before the Delhi High Court was challenging the 2nd May notification, which was before the Supreme Court. The 2nd May notification was relied upon. So the Supreme Court says that the decision on the 2nd memo should not prevent the High Court from deciding habeas.
Yes, my lord, that
Our question is that this was issued admittedly before the new act, according to
yes, my lord. Yes, my lord. Yes, my lord. My lord is relying on the Honorable Supreme Court's order dated 29/8/2025. Lordship.
Refers, you will find the date there.
Yes,
2nd
my
May 2020.
Yes, my lord.
Which
But
you have stated in your evidence.
yes, my lord.
Under which provision you have
My lord, that's
issued this memo?
my lord is asking. The question has fallen from my lords with regard to the order dated 29/8/2025 recent, which the Honorable Supreme Court has passed. That one, my lord.
Come to paragraph 11 of your evidence. You yourself have stated.
My lord will kindly play.
Paragraph 11 of
My lord,
your
my lord.
affidavit. Kindly come to
Yes, my lord.
11.
Paragraph 11. Yes, lordship.
Since India shares porous borders with Bangladesh, etc.
Lordship, may I read, madam? Kindly. I'm reading it, madam. Since shares porous borders with Bangladesh and India is facing influx of Bangladeshi nationals through illegal means, the Ministry of Home Affairs has issued specific guidelines for procedure to be adopted for repatriation of such Bangladeshi nationals back to Bangladesh. It is submitted that FRRO Delhi, being the civil authority, has been repatriating illegal migrants of Bangladesh as per instruction dated 2/5/2025.
So that is your case.
Well,
So
yes.
this instruction was prior to the date of the new act has come into effect.
Yes, my lord.
So this instruction, it has been framed under which statute, which rule, which foreign order, which foreign act?
Earlier foreign order, earlier act, my lord. That
Submission
you.
which will be made by you. Then
Yes, my
if
lord.
you are placing reliance upon this circular,
My lord.
this circular provides that before deporting, you have to conduct an inquiry for which 30 days would be provided. Just listen to our query. Then
My lord, I
in this paragraph, it is as far as we have understood, it was yesterday handed over. You handed over. So it was handed over to us, from which we find that the period for ascertaining this fact that you are not a citizen of India, you are a foreigner, because Citizenship Act, this Aadhaar card, ration card does not confer citizenship.
Lodge.
What confers citizenship is your birth certificate. Had you been born subsequent to 1969, prior to 69, what would be my citizenship? I also do not know. We didn't find anything. That is the only rider of 69 Act, birth certificate. Now, your circular which you have issued, you say that no, don't conduct a hot haste inquiry. You have to conduct an inquiry taking time of 30 days in collaboration with the state authorities, because the porous borders are with the state of West Bengal. Whoever you have handed over, which you have not yet disclosed, that how these people were sent back. You must have contacted the Bangladesh border guards and given to them the requisition that you take them back. That is a diplomatic relationship. Now, why 24th June the order was passed? Why within 2 days the person was taken back and sent to Bangladesh? First query. Supreme Court has repeatedly said that it has to be a procedure established by law. When it is Article 21, you can. The refoulement, the non-refoulement is violative of Article 21. Your Supreme Court has said. Now, what we were found was in this issue, two judgments are there.
Lodge.
Take it up. One is of Shamiullah something. Matters are still pending.
My lord will kindly repeat the name, my lord. I could not.
Yes,
quote.
I shall give it to you. But why should I give it to you? Huh?
My lord, I have
No,
always
homework
been
has to be
assured
done.
by my lords, my lord.
No.
And my lord, as far as my lord will not take me amiss, my lord. Now, my lord, I was initially doing matters of one particular type, my lord.
Yeah, that
Now, my
we-
lord, after this, I have been always, my path has always
no.
been ushered by your lordships
We
and
also
my
did
learned
other
seniors in the
matters.
bar, my
We
lord.
have been-
So, my lord will kindly give me this benevolence, my lord.
Huh?
If my lord is ushering my path, my lord will
We are
kindly.
troubling Mr. Tiwari with primary teacher matter. What can we do? Today we are on AVS conference.
আমি ওই জন্য তো বলছি my lords will kindly
See, Mr. Tiwari, we have forget about maintainability. Mr. Chakraborty has argued. Yes, we will ask him that why the deportation order has not been challenged, etc., etc. The questions which are, but please satisfy two queries of us.
Lordships.
First is this deportation order. If you kindly come to. That is at page 58 of your affidavit. Type
Yes,
copy.
yes,
Here.
you come.
May I make one submission? That
we
is
are-
detention order, not deportation. Kindly see, my lord.
Oh, I have said deportation.
Yeah.
I am wrong.
Detention.
That is detention. Yes, you are absolutely right.
Deportation টা লাগাইনি না।
That is a detention order.
You have handed over.
Page 58, typed copy, my brother says is in page 62.
Well, 58, my lord.
24 June, page 58.
Yes, I'm at
Issued by your FRRO.
Lordship.
Now kindly see. The above, after that column, the above mentioned persons have been detected to be illegal migrants. They are failed to
Provide the suitable reason for supportive documents to justify the illegal entry, overstay in India, and produced by SHR so and so, New Delhi. The above named foreigners are not will not move out of the community center.
The above named foreigner will not move out of the
Community center.
This community center is in under your new act. Check it out.
Under the old act also, my lord will kindly see if
Please
kind
say
of Foreigners
which
Act,
person.
section 3E, they have said that at such place they can be put. If my lord's Foreigners Act, my lord, requiring him to reside in a particular place.
Just
My lord, Foreigners Act,
Yes, section
3 2E, my lord, that power comes from there. Now they have named it, and subsequently, since what name was coined before, in the act also.
Kindly come to page 66.
Lordships.
This was the procedure adopted by you. Now see, it is recorded such and such have come to the police station, and the situation is such that my SI, along with accompanying staff, while searching for illegal Bangladeshi citizen, reached Bengali Bosti at around 3 p.m., where a special informer met and informed that in a short while a Bangladeshi man is going to come here to meet someone. HC, head constable, along with accompanies, along with special informer, started waiting for the Bangladeshi man. So you have already spotted that he is a Bangladeshi man. At around 3:30 p.m., seeing a person coming towards us, the special informer pointed out that this is the Bangladeshi who is living illegally in Delhi. We don't know who is your special informer, what material you had from him, nothing. Apply, you are our officer, Mr. Trivedi. When the person was stopped with the help of the accompanying staff and questioned, he told that he is a Bangladeshi citizen and his full name and address is such and such, residing at Bangladesh, and he has come to India illegally. Only his statement, only on the basis of his statement, that he himself has said that I am a Bangladeshi. So we are taking you. Now, after this was done on 21st of June, 24th June came the detention order, and 26th June deported. Why this hot haste? Why this hot haste? This subject to what you say.
My lord, I am understanding what is falling from my lord. Then, my lord, I will assimilate, my lord, and then I will answer, my lord. I don't want to make any submissions of the cuff.
ও বলেছে আমি
Because some pertinent questions are falling from my lord. Yes, my lord, I gather.
SOP says within 30 days the
Lodge.
investigation has been
Lodge.
done. Indisputably, within 2 days he was removed, he was deported. Now, within that 2 days, did the police conduct an investigation? Is there an inquiry report to that effect? Go through, because
Lordship, I totally bow down to what is falling, my lord. Therefore, my lord, I am not wanting, my lord, impromptu answers, my lord. Let me, my lord, my lord, at the very outset, my lord, I beseech, my lord, I said that as far as factual aspect, the rigmarole of events, as far as this case is concerned, my lord, it was such, my lord, that today we are having a hearing on merit and also on maintainability. So, my lord, will kindly, I beseech, my lord, let my learned friend make his submissions. And, my lord, as far as maintainability is concerned, my lord, 1 or 2 points more we will try to address your lordships.
Yes,
This has been
let's-
about my learned friend will
But
argue as far as he will take the baton from learned ASG where he has left
No,
it.
he has
And then, my lord,
finished
very
He has finished only 2-3 things I will say. So far as
let him answer this query. Yes, what more?
Tiwari, you are adding to what Mr. Chakraborty has said.
only 2 things, the order of deportation is dated 26th of June 2025.
So when was give us the dates? When was the writ petition filed before the Delhi High Court?
the first writ petition was filed before the Delhi High Court, Lordship. The first
Deportation was on 26th of June 2025.
Yes. Now, writ petition was filed, on subject to correction of my learned friend, 25th of June 2025.
Prior to deportation.
No.
There are 2 writ petitions, my lord.
First writ petition was on 25th June.
27th, my lord. The Wakalatnama is page 29. 27th.
First writ petition
My lord,
was
first
on
writ petition. My lord, I'm coming.
24th. This
My lord,
Page 12, my lord, 23rd.
no,
Page
no,
12 of their affidavit, Leela Prasad,
Leela
daughter of Sri
Leela-
Chandra Bhushan Prasad, FRO, assistant FRO. Page 12, my lord, R1. What you will find in the middle portion, date is 23rd June 2025.
No.
So your first writ petition was 23rd June.
Yes.
My lord, will kindly see the Wakalatnama.
No, anyway, there it is a different.
My lord, I shall point all these facts, my lord, when I make my submission on maintainability, my lord.
All right.
Because I am following my affidavit.
23rd
And
June,
this affidavit is, my lord, my learned friend is following. So therefore,
23rd June is the first writ petition, which was withdrawn on
Drawn on, my lord.
30th.
30th of June.
My lord, according to my understanding, lordships will kindly see.
No, where is that first Delhi High Court order? That was here.
Delhi High Court first order, my lords may take, my lord, my affidavit, that is by.
Mr. Trivedi, we are going by this. We take up your.
My lord, I apologize.
Page 31.
Lord, if your lordship will not kindly take page 31 of the affidavit affirmed by the respondent number 1 to 4.
Acha, please read the order of this. Please read this order.
Yes, page 31, my lord, order dated 30th of June 2025.
Yes.
It says, my lord, both the writ petitions which involve the same question have been taken up together.
What are those 2 writ petitions? 2 writ petitions.
2 writ petitions.
This corpus challenging.
Your lordship would get it, my lord, page 30, my lord, the details of the writ petition.
Second writ petition was filed when? First writ petition was
9/7.
First writ petition was habeas corpus.
Both.
Eh?
Both the writ petition in respect of
No.
First writ petition is challenging is a habeas corpus. Second writ is challenging
the order of deportation.
Yes, challenge the order.
That is 26 June.
No, my lord, not 26 June, lordship. That is 9/7. That is 9th of
9/7.
July.
9th of July.
9th July 2025. Now both these writ petitions were heard on 30th June 2025.
No.
My lord, will first
Then
writ
what is the first writ petition order?
First writ petition.
Page 30, my lord, your lordship.
Page 31.
30th June.
30th June. First writ petition withdrawn. Second writ petition withdrawn. 12th of August.
এটাতে কি Status request contains deportation order of 24 June. এটা তো 20 ওটা কি অর্ডার 9 জুলাই বলছে তো ওটা ডিপোর্টেশন অর্ডার না that is challenging 26th of June 2025.
Yes, 26 June 2025.
Then the first writ petition was filed challenging what?
First writ petition was filed, my lord, praying for release. This is in the nature of habeas corpus.
Acha, second writ petition was challenging 26 June.
If your lordship, my lord, can you take, my lord, page 30 once, everything will be clear. Page 30 of my opposition, 1 to 4. 1 to 4. Page 30. Now, my lord, kindly see, my lord. One writ petition is WP CRL 1927 of 2025, filed by one Karishma. And second one, WP CRL 1928 of 2025, filed by one Lajila Bibi. Now, my lord, kindly turn, my lord, next page, page 31. Page 31, may I just place it. Both the writ petitions which involve the same questions have been taken up together. In WP CRL 1927 of 2025, petitioner seeks directions for production of Sonali, Danish Sheikh and minor S. And in WP CRL 1928 of 2025, petitioner seeks direction for production of Mrs. Sweetie Bibi and minor case. Mr. Sassan Sir's London Standing Counsel for the respondent state appears on advice, on advance notice, and submits that all such 5 persons were found to be illegal migrant from Bangladesh, and when they were asked to produce the documents to show and demonstrate that they were citizens of India, they failed to provide any such documents. Resultantly, they were taken to the police stations where, on examinations, they admitted they were citizens of Bangladesh and were born in Bangladesh and had illegally entered into India. Mr. Sassan submits they are all accordingly, therefore, thereafter produced before the competent authority, that is the FRRO, RM Puram, Delhi, hereafter referred to the FRRO, where after due verifications, order of their deportations has already been passed and they have already been deported to Bangladesh on 26/6/2025. Status report has been submitted in both the matters, which is taken on record. It also contains the deportation order dated 24/6/2025. A copy of the status report has already been furnished to the Learned Counsel of the petitioners. Learned Counsel for the petitioners submits that in view of the above, he does not press any relief in the present two petitions and would file appropriate petitions challenging the aforesaid order dated 24/6/2025, and accordingly this was disposed of. So, my lord, second round of petitions filed before the Delhi High Court challenging the order of deportation. That is, my lord, 24/6/2025 and 26/6/2025. Now, my lord, both the writ petitions were pending before the Delhi High Court. Now, my lord, again, my lord, move before this Honorable Court, praying for habeas corpus. Now, my lord, subsequently,
No, this was withdrawn.
This was withdrawn on 30th of June 2025.
Yeah, just a moment. Where a withdrawn order is there?
Yes, there is a withdrawn order, page 31.
Page 31.
Has been filed.
Now he filed in Calcutta High Court.
Now,
prior to
this
that,
writ petition, Calcutta High Court writ petition was filed on 8th of July 2025. This WPA H 50 of 2025 was, my lord, affirmed on 8th of July 2025.
And Delhi second petition was filed on 9th.
And Delhi will second petition filed on 9th.
During pendency of this petition.
This petition. So, well, this is a case of
Calcutta High Court filed the writ petition on 8th July.
8th July.
That is after withdrawing those two writ petitions.
No, first writ petition.
After first two writ petitions were withdrawn on 30th.
First, not first two. First was withdrawn on 30th of July during the pendency of the second. Then they filed the Calcutta High Court on 8th. On 9th, they went to Delhi, filed the second writ.
Yes.
On 12th of August, they withdrew the second writ in
Second.
Delhi,
Yes.
and now they are proceeding.
Yes.
Lordship, that
Yes.
is.
This is the fact. This is the fact.
First writ petition was habeas corpus filed on
23rd June 2025.
23rd June 25. The second writ petition was
Challenging the detention
26
of
June. Now
9th July 25.
9 July 25.
Second writ filed. Delhi. Second writ
হলো দুটো রিট পিটিশনই একসাথে নিল 30th
30th June first writ withdraw.
যেটা হেভিয়াস কর্পাস
হেভিয়াস কর্পাস করছে যে বললো আমরা
সেই অর্ডার
ডিটেনশনটা চ্যালেঞ্জ করছি
এইটা
বা ডিটেনশনটাকে চ্যালেঞ্জ ডিপোর্টেশনটাকে চ্যালেঞ্জ করছি
ডিপোর্টেশনটাকে চ্যালেঞ্জ করলো 9 জুলাই
9 জুলাই তার
দিল্লি
মধ্যে
হাইকোর্টে
তার মধ্যে 8 জুলাই কলকাতা হাইকোর্টে একটা
হেভিয়াস কর্পাস এবার ওই সেকেন্ড রিট পিটিশনটা
হলো অন 12th of August
সেটা কি যেই সেকেন্ড রিট বিফোর দিল্লি হাইকোর্ট করেছিল
তারপরের দিন সেকেন্ড রিটটা ফাইল
না না সেকেন্ড রিটটা 12/25 এ সেকেন্ড রিটটা উইথড্রন তার মানে দুটো রিট পিটিশনই বের হলো এবার
উইদাউট এনি ফাইল
dismissed as written কিন্তু রিট পিটিশনার দেয়ার ইজ নট দি সেম রিট পিটিশনার
কিন্তু খেলাটা একে যে একটা আমি জানতে চাইছি গ্লাসিলা ভিডিও দেখছি কারণ যাবে যাবে সেটা কোথাও ডিসক্লোজ
all right yes what you have to say
Milord, I want to say, Milord, the order of deportation
now in the writ petition filed before us after Delhi High Court withdrawal the writ petition in the writ petition 8 July it is a habeas corpus petition here the deportation order is not under challenge
now, Milord, kindly consider one thing. Milord, they had the knowledge about the deportation order, Milord, on at least on 30th of June 2025. Why I am saying so? As because on 30th of June, the order of the Delhi High Court is there. So, Milord, it was supplied. Order of deportation was supplied by the Learned Council, Milord, representing the union or Delhi administration. The copy of the deportation order was supplied to them. But can you see the order dated, Milord, 30th of June? Again, I am reading. Last.
Very good, very good.
Milord, they had the knowledge. They had the knowledge about the deportation order. So, deportation order is 26/6/2025. Now, Milord, despite having knowledge of the order of deportation, they again filed the writ petition before this honorable court. Milord, saying, the look here, this is a read in the nature of habeas corpus. How it is maintainable? I am asking the question to myself. Can a order, when a deportation order has been passed by the FRRO, under rightly, wrongly, whatever it may be, whether it can be challenged by a habeas corpus writ? It cannot be, Milord. He has to challenge this order by filing a appropriate writ petition before the appropriate writ jurisdiction. Whether it may be Calcutta High Court or it may be Delhi High Court. But if any, Milord, it has to be heard by the single judge of this honorable court or by any other appropriate judge of the Delhi High Court. Well, how the writ petition in the nature of habeas corpus is maintainable?
They will be taking the ground that the petitioners were different.
No, Milord, he is asking for relief in respect of same petitioners. This is the question.
One was for release of the same petition.
Yes.
And the other one was release of some.
No, Milord, the same. Everything
Milord,
same.
see, Milord, page 31. Page 31.
Yes.
See the second paragraph.
Yes.
Second kindly, you people are.
It says, Milord,
first
1927 petitioner
Danish Sheikh.
Danish Sheikh.
Next writ petition is of Sweetie Bibi.
Yes, subsequent 51. Next,
51, which my
next,
laws is in
my laws list, Milord, WP, Milord, 51 is Sweetie Bibi.
So now who has filed? The same person has not come.
Same person has not filed. Two different persons espousing
They
the
will take that point. They will say, we are not the same person. We didn't know about.
Lord, they are asking for the release of the same persons. If I may, I am asking for release of X before the Delhi High Court as well as Calcutta High Court. Can I say that I am not the same person? But it is a case of forum shopping. With deepest of respect, I am saying. But taking chance in every court.
All right.
They had only two things, Lord. But so far as, Lord, this order of deportation, Lord, my submission would be, Lord, it was handed over to them on 26, at least on 30th of June 2025. Now, Lord, if your Lordship, Lord, kindly takes the order of deportation, that is on 26th of June 2025, last page, your Lordship would find, last page. Well, their names are appearing, Lord, serial number 61 to 66. Page, Lord, 1, 2, 3. Third page, serial number 61 to 66 are these persons. Now, my lord, if your lordship, my lord, kindly takes on the last page, your lordship would find received 163 Bangladeshi nationals and they were deported, my lord, through Guwahati, Assam. At least, my lord, either Delhi High Court or my lord, Guwahati High Court has the jurisdiction. And these documents are available to them on 30th of June. But there must be limit of suppression, my lord. From the Delhi High Court order, it is apparent that these documents are handed over to them. Now, if these documents are handed over to them, they could have challenged this order by filing a writ petition. Why this habeas corpus on 9th?
Very good. Yes.
My lord, certain aspects, my lord, just regarding the daily.
Let him give the
And my lord, only one thing, my lord. So far as my lord, Foreigners Act is concerned, my lord, if your lordship, my lord, kindly takes, my lord, section 9, section 8 and section 9. Well, section 8 says, my lord, determination of relationship, and section 9 speaks about the, my lord, burden of proof. It is his burden to prove, my lord, he is an Indian. Lord, if somebody says, Lord, I am a Bangladeshi national, I reside in Bangladesh in that place.
Your
What
SOP says
difference
that,
to prove?
all right, we are trying to ascertain that how you have taken that decision.
Yes.
This was done within 2 days.
Lord,
Whatever may be your explanation, facts cannot be denied.
30 days.
24th was the detention, 26th go, lock, stock, barrel sent from Assam.
Lord, outer limits.
This procedure, how you will be supporting.
Yes.
If we dismiss it on the maintainability, then everything goes. Otherwise, you have to satisfy us
Will satisfy
that any person you will catch, and you referred, it is Bengali Bosti. You referred, that was your observation in the order.
Lord, don't go by these observations. Lord, kindly consider one thing. Lord,
that is your observation. Your officer said
30 days. Lord, 2 days inclusive of 30 days. But 30 days outer limit, that does not mean that I cannot do
yes,
it in
that
2 days. I
no,
can
no,
do it.
no, sorry. That is the outer limit is 30. In emergent cases, you have to disclose the reasons that why I am taking within 2 days. Your officers are
in that
also,
so far as that aspect is concerned, we will address it.
we want your answer.
Yes, we will address that issue.
My lord, just
Maintainability, throw it out, that is another thing. Maintainability will consider. You are under an obligation to answer our queries.
Obviously. Lord,
Yes, tell us.
kindly consider one thing, Lord, we have not used a detailed affidavit. Which only
It was for your fault. Your time was given, you did not use it.
Only Milord,
Then maximum pay for extension of time, whether we
only Milord, so far as the state is concerned, only one thing.
Sir, Mr. Banerjee, we
No,
are
no,
not getting
exchange of affidavits, but no, no copy, no copy, no copy has given to us.
We have not been given also.
That is only on point of maintainability.
Yes, tell us.
My lord, certain facts on behalf of Delhi police. My lord.
So maintainability.
Maintainability only. We are only on maintainability today, lordship, because I am unable to answer whatever has fallen from my lord. Whatever, my lord.
Yes, what you.
My lord, just
anything extra?
Yes, my lord. Something which has not been stated, my lord, I am just not more than 5 minutes. If my lord kindly takes up my affidavit, which is the affidavit of respondent number 5. Millard, which could not be those aspects, nothing else on fact. Now, Millard, the first thing, Millard, there are two writ petitions before your lordships. What had fallen, Millard, that who are championing for their cause, the petitioners. Now, Millard, what happens is, as far as 50 is concerned, Bhodu Sheikh, he claims to be in paragraph 1, the father of Sonali Khatun, grandfather of minor Danish, and father-in-law of Sabir Sheikh and father-in-law of Danish. So he claims to be the father. Now, the other writ petition at New Delhi, which was filed on behalf of Danish, Sonali, and Sabir Sheikh by one Karishma, who claims to be the sister. So therefore, my lord, both are from the same family. Over here, before your lordships, is the father claims. And in Delhi High Court, it is the sister. Now, my lord, as far as the petition is concerned of Bhodu Sheikh, which my lords are having a look, if your lordships kindly comes to page 33. My lord, but certain facts are very much important. Bhodu Sheikh, that writ petition 50.
Yeah, that has been shown. It was.
My lord, what they have not shown, I am trying to show, my lords. Who has made this? Because what question has fallen from my lord is about championing of cause. That is what I am trying to come. My lord, this gentleman, Bhodu Sheikh, who is the petitioner before my lord, goes by this representation at page 33 and says, I am going to go to Delhi High Court. He cannot say that he was not aware of Delhi High Court petition. That is what I am trying to point out before my lord very humbly. Representation at page 33. Because it has fallen from my lord, no, that he did not know what this hand does not know what the other hand does. So, my lord, this particular point, I am trying to impress very humbly before my lord that this gentleman knew everything on 6th of July. That is after filing the first writ petition and after dismissal of the first writ petition by Karishma in New Delhi. This Bhodu Sheikh, after dismissal of Karishma's first writ petition on 30th, which was withdrawn with liberty to challenge that deportation order, he files a representation on 6th of July 2025 saying that yes, everything has happened in Delhi and I am going to move New Delhi, High Court at Delhi. Be that as it may. This is my first point. Now, my lord, as far as Amir Khan is concerned, the second writ petition, he claims, as far as Amir Khan is concerned, he claims to be the paternal biological cousin of Sweetie Bibi. Biological paternal cousin sister happens to be Sweetie Bibi. Now, the other writ petition which was filed on behalf of Sweetie Bibi before the Honorable Delhi High Court was filed by one Lajila Bibi who claims to be the mother. Now, my lord, and my lords will kindly see at page 33, this Lajila Bibi or Ajila Bibi has made this representation at page 33 of this 51, my lord. Well, I apologize, my lord, I am taking both because, my lord, this thing needs to be clarified. My lord will kindly see second writ petition at page 33.
Yes.
This is 8th July 2025 representation. This is again after the filing of the first writ petition. And, my lord, this representation is being made by Lajila Bibi, who has the writ petition at Delhi High Court at page 35.
No, this representation made by one Shahil Akhtar.
My lord, my petition, my lord.
Page 35.
My lord, page 35, my lord, at the late Ajila Bibi, then LTI of Muhammad Shakil for Ajila Bibi. Ajila Bibi.
Anzila Bibi.
Anzila and Lajila, my lord, that may be, my lord, but then, my lord, I am trying to show what is the chaos. The question which had fallen from my lords is that he did not know and he knew. My lord, I'm just trying to clarify that aspect. They are working in cahoots, my lord. They knew, they wanted to file in new. And then what happens, my lord, when this representation is made on 8th, writ petition before this honorable court, has been filed when? If my lord kindly sees. On 8th it has been affirmed. On 8th it has been affirmed. Affirm bolchi to. So my lord, there the other person, he is filing, my lord, a representation, and here they have affirmed on the 9th the writ petition was filed, and simultaneously a writ petition was filed there, my lord. And there, my lord, they challenged the order of deportation which was there, and they were very much having that particular order, and they were having that knowledge. So, my lords, the writ petition which is before my lords smacks of suppression of material facts by these petitioners also. They could have stated all these comprehensive writ petition before my lords, stating that on 30th this happened, 26th they were deported. It would have been, I of course keeping that point, but I am on, because of jurisdiction, cause of action, all has been taken care of by my learned friend.
All right, thank you. Yes, yes.
And my lord, one more, my lord, I apologize, my lord, 30 seconds of amnesty, my lord. My lord, the order of withdrawal, my lords will kindly see. No leave has been sought for. No leave, my lord.
Permission to withdraw granted.
Withdraw, my lord, leave to challenge that deportation order before this honorable court.
That is page 30.
My lord, will kindly see the two orders. It is on instruction of the learned counsel for the petitioner seeks permission to withdraw the petition. Permission to withdraw is granted. Order 2, Rule 2, my lord, and this is, my lord, I have to take leave.
And in the earlier one, any leave was?
No, yes, my lord, leave was granted. If my lord kindly comes. Ek second.
No leave was granted.
Ek second. Our petition. My lord will kindly take up page that
50.
50, my lord. Lordship will kindly allow me to come.
Counsel submits in view he does not press for any relief in the present and would file a petition accordingly disposed of.
My lord, first leave was granted for taking up, my lord. Leave was granted. Second, no leave has been granted. So, my lord, first leave granted, taking recourse of that leave, they challenge the deportation order, then do not want to bring it to a logical conclusion, withdraw it abruptly, and then they are trying to, my lord, take that cause over here and want to go forward with it, my lord. I'm asking a question to myself, my lord. And nothing has been prayed, no statements have been made with regard to these facts.
Against the deportation.
My deportation, not even a single word in the writ petition. What I will answer to? Whatever submissions have been made from the bar or documents which we have produced before my lord. Until and unless my lords decide that yes, it is maintainable, you will amend the writ petition or bring it by a supplementary affidavit. The supplementary facts which have been brought before your lordships from my side, total suppression in his writ petition, what I am going to answer to. And my lord, even if habeas corpus, my lord will kindly see the prayer. It's the highest prerogative. Again, my lord, I don't want to because they have already made, but my lord, I have to touch that line. That, my lord, what is there, my lord, if today I'm asking a question to myself very humbly, my lord, if I'm asked to file my affidavit in opposition, on what basis I will file my opposition and why should I disclose documents which not even a single word has been mentioned regarding which in the writ petition? So, my lord, as far as today is concerned, my lord, until unless a supplementary affidavit is filed or this writ petition is amended, my lord, what I will answer to? My lords have, two queries have fallen from my lords. My lord, we will try to satisfy my lord on the other.
The outset, my lord, on 11/7/2025, lordship, my lord, the order dated 11/7/2000.
Lords, may I take my lord's leave for 5 minutes, my lord? The matter is going. I'm just, my lord, I'll be back within 10 minutes.
So the deportation order is not under challenge.
Never supplied.
Yes.
And in court itself.
In court it was supplied.
No.
We come to page 38.
Yes, my lord, I'm coming. Before that, my lord, may I draw lordship attention?
You have to show us, na? You are saying a statement that it was not supplied.
Yes.
Let us check up that submission of
Yes,
yours.
yes.
Page 38, na? that order? Where did you say that it was handed over?
It's page 32 of my opposition, 1 to 4. Page, there is 50.
Page 32.
Page 32, not paragraph 6.
A copy has been furnished to the London Council for
The copy, my lord, page 58 only.
Page 32.
30, I start from 31. Lordship, third paragraph. Well, this particular information has been communicated before the Honorable Court that the citizen admitted was born in Bangladesh. Thereafter, next paragraph, all were accordingly thereafter produced before the competent authority, where after due verification, order of the deportation has already been passed and they have already been deported Bangladesh on 26/6/2025. And the order was passed on 24.
Finish it off.
That's
finish of the next
yes, yes, my lord. Such status report has been submitted in both the matter, which is taken on record. It also contains the deportation order dated 24/6/2025. This is termed as deportation order. Our humble submission.
Detention.
Yes, detention. A copy of such status report has also.
So your statement is 26 June was not handed over to you.
24th June order has been handed over.
26 June?
No,
not.
no.
Where is
26th is the date for deportation.
Achha, very good. Where is that statement in your paragraph? It was not given to us.
No, the only difficulty.
Please, one by one.
Yes.
Show us the statement that I was given only the 24th order, not the 26th order.
No, I'm coming. Lordship, kindly come to our reply.
No, writ petition.
No, writ petition at that point of time we're in dark.
So you admit that in writ petition there is no such.
No whisper. Only whisper is there. They are deported.
So you have on the writ petition which was filed.
Yes, my lord.
Where is that statement?
Yes.
That I have been given 24th June, not the deportation order of 26th June.
Because of, my lord.
Have you stated it?
But I one paragraph I'm showing.
Yes, paragraph.
One paragraph I'm showing, my lord. Lordship,
so in writ petition there is no statement.
Yes, my lord. Kindly come to, my lord, one paragraph. Para 3, page 4.
Para 3.
Para 3, page 4.
Yes.
The detainees Danish Sheikh, his wife Shunali Khatun, and their minor son, so are Indian citizen by birth. They are permanent resident of West Bengal. Mr. Shunali Khatun is the petitioner biological daughter. For lawful employment, the detainees migrated to Delhi. They were worked in the informal sector, including construction and sanitation. This kind of migration is common. Many citizens of West Bengal, Bihar, Odisha, Gujarat, and Maharashtra moved to cities of Delhi, Mumbai, Ahmedabad for work. These workers support the so-and-so economy, my lord. The petitioner father Hatim Tai Sheikh was a registered, my lord. Then, my lord, I am drawing lordship attention.
There.
Yes, I'm coming. Paragraph 10. Paragraph 10. Paragraph 10. Accordingly, according to the reliable accounts, page 6, from others who were detained and later released, as reported in the press, the detainees are first held in a detention center in Delhi. They were then medically.
If you want to read the entire petition, that is one.
Lordship.
Please answer our query.
Lordship.
Then you proceed as you wish.
Lordship.
We are simple question we are asking. Where in the writ petition you have stated that the 26th order was not given to me.
My lord, at that point of
again you are saying yes or no. Please tell us.
No, my lord. I humbly submit no.
So then, when you have not stated that it was not given to you,
lordship,
that is why you could not have, you were not able to challenge the same. That will be the logic.
Deep level.
Then how you will substantiate in this writ petition that the deportation order is bad?
No, my lord.
Deportation order is not under challenge. Deportation, if we hold that it is wrong, then there will be a question of illegal detention. Unless we hold that deportation is bad, you cannot say, you cannot tell us that you are in unlawful illegal detention to exercise the writ of habeas.
So, my lord, at the threshold, lordship directed them, my lord, to file their affidavit. They have disclosed certain things which is at par with our apprehension, my lord.
Mr. Chakraborty, a maintainability point is being urged.
But I'm trying to satisfy this.
You are not trying. You are avoiding the answer the court wants.
Because of at that juncture, my lord, certain information not available.
How can you take it so easily? It
No,
becomes forum shopping.
My lord, what is our alternative at that point of time to
You should have
unless
challenged that order.
unless to my lord, kindly I have
8 July was the writ petition affirmed.
Lordship.
Was it not your duty to wait for another day and get the order of deportation and challenge the same?
Oh, my lord, the only thing is in my lord, Delhi, my lord, there is lack of coordination. My lord, they are the my lord domestic maid went there. That I have stated in my reply and very specifically.
Cannot be a ground because the subject matter of the writ petition today, if we cannot touch the deportation order, we cannot give you the benefit.
So, detention order is bad, my lord, subject to correction, my lord. That is available with this. My lord, true.
Detention order has marked.
If detention goes,
Detention also you have not challenged.
my lord, detention, my lord,
Detention have you
only
challenged?
in their affidavit in reply. Only in their affidavit they have enclosed this particular
Prayer
document.
in the writ
My lord,
petition.
I am coming into the
Where is that prayer that you have challenged the detention?
My lord, kindly see, my lord.
Go through the averment, Mr. Chakraborty.
Lord,
It
say
takes
true.
time.
True, my lord.
You
True.
give some time to yourself to answer our query.
No, my lord, the only difficulty, my lord, kindly realize, my lord, the difficulty is, my lord, they are domestic made. Some of the person went there. I can show from our affidavit in reply.
Mr. Chakraborty, that is not a ground. We are going to dismiss your petition. When you cannot answer our query, what we will hear you?
No, let's so but the question of
Hearing us.
question of jurisdiction they have raised.
Question of we are asking you.
Lordship.
Where is the statement that you have not been given the order of deportation? You have made a statement. There is one statement. Detention order is referred to in the Delhi High Court.
Lordship.
So immediately you took the point that detention order was given, not the deportation order.
So
we then asked you in answer that, sir, where you have mentioned that deportation order has not been given to you. We are trying to assist you by saying that give us the handle so that we can get in touch with the deportation order.
Lordship.
If we can say that deportation order is prima facie bad,
Lordship.
then a question of illegal detention and production of the person will come.
No, may my lord, lordship, subject to correction, my lord, I understood, my lord. The only difficulty. No, lordship can. Lordship can.
The present.
Well, they did not comply the circular, deported immediately, and they did not consult the state government also. These are the infirmities. So far, these habeas corpus.
Aware of these infirmities, why didn't you mention in your writ petition?
No, my lord, they are claiming from the very outset, my lord, this is the deportation order.
Even we are asking you
lordship,
that so many infirmities you are pointing out. As it has fallen from us, you are
True, my lord.
you are taking this point. You are right.
True.
We will question them.
True, my lord.
How this was what, but we must have the jurisdiction, Mr.
Lordship.
Chakraborty, unless you give us the handle that see part cause of action is here. There. What is the main point? Main point is your question of challenge against the deportation is not there in the writ petition. Then what we will answer? We cannot catch hold of them that your deport. Had there been a subject matter, we could have caught them. Then they would have to satisfy that yes, this deportation order is right, this is wrong. This is our only query. You satisfy, we pass the order. But today it doesn't seem that you are ready to give us that answer. Tell us when can you, yes, when can you file that file? Yes, state, what do you have to say? You have nothing to say.
So we have only the writ, except the writ petition, we don't have anything. Neither the affidavit copy, nothing. Nothing has been served to us, my lord.
Why you are a co-respondent?
Yes.
Why they will serve? No, if they
Nothing
do
has-
not
yes,
serve,
my lord.
CD was lost with them, my lord.
They must have made some inquiries regarding whether there are prison or not.
বুঝেছে না এখানে আচ্ছা show us the GD which was lost by your father. Have you annexed that?
Yes. Lordship will find from our affidavit in reply. Affidavit ওই জিডিটা যেটা আমরা ওখানে চিঠিটা দিলাম স্যার affidavit গুলো দিন রিপ্লাই গুলো দিন
পুলিতে করেছিল আচ্ছা when you will file your opposition main opposition
লোকটা দিল আপনার বীরভূম দিয়েছে স্টেশনে আছে
হ্যাঁ এটা তো আমাদের এ করে পাঠাচ্ছে না সার্টিফাই করে পাঠিয়েছে সার্টিফাই টু উইথড্র
না ওই এটা জিডিটা চাইছেন
No, no, it has been submitted by the Pakur PS. OC Pakur
Mr.
Birbhum.
Chakraborty,
yes sir
you check up the petition
Lordship.
as to whether there is any statement that you were not given the order of deportation.
Lordship.
Now, deportation order was not yet, now you have got it. So in this stage of affairs, do you want to amend the petition? That is another question.
Lordship.
If you say that now I want to amend, they will oppose. You have to come with an amendment application.
Lordship.
But the situation as it is today, they are already in Bangladesh. Their deportation is not under challenge. Then you will be rendered remediless. Think what you will be doing. I think you are also not being given the total information. This Lazila, this other person is coming. You are a council. You cannot run behind them that you give me this data. If they cannot satisfy you, what can be done?
Already in our reply, my lord, what the exact state of condition, my lord, I have enclosed.
You are at
True,
least,
true, my lord.
you
True,
know
my lord.
that thing which you have not stated in your petition. Your reply cannot come to your any assistance.
May I make one submission, my lord? In utter desperation, I am making this submission. Every document before this honorable court, when the, my lord, the foundation is laid, subject to correction, my lord, this is a...
Show us any authority.
I'll show, my lord.
Yes,
Subject,
show, give us-
foundation-led relief can be molded, my lord. This court can do that.
Relief will be molded when
True.
the challenge is there.
No.
If the challenge is not there,
Some-
how can we mold and say that I am setting aside the order of deportation? Try to understand. There was a
Lordship.
limit to everything.
Lordship.
There is no ground. We are being, since you have argued that the lady was there in a
Bangladesh.
deplorable condition, we were trying to finish it. Now you remembered your problems. Neither you have challenge is there. Now amendment applications, they will not so easily. They will object to it. Then what are you
Till today, my lord, no deportation order, my lord. No order is there.
That I think Mr. Chakraborty is not a
Only
correct instruction given.
My lord, the detention order is there.
It is very difficult to accept that.
My lord,
4 writ petitions.
I don't know, my lord, whether they have supplied the detention order or produced before this honorable deportation order before this honorable
That
court.
status
No
report
copy has been
itself would
supplied
show.
to us. We are not also aware.
Mr. Tiwari, you bring that copy of the status report.
Can bring the status.
In to us, my lord.
That is your contention. We
Yes.
will ensure that
Yes.
deportation order has been placed before us.
Deeply
We will record that your statement that it was not given to us.
Yes.
Now, habeas corpus, we can at least think about this, that you will withdraw the habeas corpus with the leave to challenge the deportation order before the appropriate forum. Try your luck. Then it will. That is for you to decide, because This we have told you
Lords.
that what are the difficulties in
Lord.
overcoming the argument advanced.
Lords.
Your argument you will make, but you are for the persons who are
Suffering.
if the deportation order challenge is before a particular forum, then you can make all sort of arguments. This illegal 30 days required, only 2 days thrown away. Informer said he's a Bangladeshi, went to Bangla.
Lordship.
Otherwise, how we can? You do one thing.
Lords.
You take that instruction and come back to us. That if you don't want to, we can sort the problem in that fashion, leaving your challenge against the deportation order to be tried by the independent forum, as they have rightly said. That we are that instead of making an amendment and urging for a writ of habeas corpus, deportation order goes naturally because there is an example. Another person during pendency has come back. You only told that.
Yes, sir. They have taken a, my lord, the
Think that will be a better course of action. So we keep it as to be mentioned day after tomorrow. You take the instruction.
meanwhile direct them, my lord, to supply the copy of deportation.
That you leave it upon us.
Lordship.
If you withdraw and say that I will challenge the deportation order,
Lordship.
we will give you the copy of the deportation order.
Deeply
What is we cannot. We have the deportation order.
Taking instruction, I will come back.
Mr. Chakraborty learned additional Chakraborty has handed over.
No, Millard, that deportation order we have given Millard. He has not.
No, my lord. 2nd May, my lord, day before yesterday, we have handed over. Yesterday.
No, they gave a copy of this order.
Yes.
No. He.
No, Millard, deportation
No,
order
no,
was
no,
given
no,
by
no.
us. Millard,
হ্যাঁ,
SOP
ঠিক আছে।
was given
আচ্ছা,
by
আচ্ছা,
Millard.
ঠিক আছে, দিয়ে দাও, নিয়ে নেবে।
Secret document.
Millard,
আরেকটা?
Millard, we may keep it in an envelope and Millard, hand it over to your lordship's officer.
এই এরকম আরেকটা অর্ডারের কপি ছিল, ওই দুটো ওকে ফেরত দিয়ে দাও।
এই কোনটা কি হয়েছে?
আরে সব গুলিয়ে গেছে বর্তমানে এত আরেকটা লাগি না আর ওইটা কনফিউজ
You gave us 2 copies.
actually identical to writ petitions, facts are also identical. This is bound to happen.
হ্যাঁ, সম্পত্তি রেখে bring it on that day.
We shall.
Mr. Bosu
রূপম,